For judgment, item number 1.
The writ petition is dismissed.
Obliged.
You'll have to get it signed by.
My lord. My lord, may I please your lordship, my lord? Actually, under compelling circumstances, I am making a mention today, my lord, right now. The thing is like this, that on the last date, my lord, an order was passed that the matter should be listed from the week commencing from the 21st. So accordingly, my lord, my assisting counsel took up the matter with the registry, my lord, and they said that it will be listed today. But somehow it is not listed. So I pray, my lord, can it be taken up today after the end of the list, my lord? It's a criminal appeal hearing, my lord. I'll not take much time also, my lord, because I have prepared the written synopsis and all things, my lord.
Commencing from 21st October.
Yes, yes. So accordingly,
So it could be any day,
yes, yes, absolutely there. my lord.
tomorrow, day after, till Friday.
No, it's all there, my lord. No doubt of that. But my assisting counsel took up the matter with the registry, my lord. Registry said it will be listed on 22nd. So accordingly, we made preparation and appearing before your lordship today. But suddenly it's not listed. Then again in the morning it was verified, my lord. Then the registry says there is a connecting matter. But unfortunately it cannot be connecting because he is the sole accused who has been convicted in this case, my lord. Only appellant, my lord. I think registry...
See, Mr. Ziaul, one thing is that, see, if it's not listed, now what about the other side, public prosecutor?
Other side probably...
And they'll have to be ready.
She says, my lord, he has contacted her, my lord. She says she will virtually appear, my lord.
And we have
I'm just leaving it to your lordship.
we
my
have two fixed matters also
lord.
today.
I'm aware, my lord. I have taken stock of that.
So
That's sufficient, my lord.
this will be, even if it's allowed, it will be the last item.
Let me take a try, my lord. If your lordship permits me.
It's up to you, but I doubt it whether we can take up this matter today.
Then tomorrow can it be taken up as a preferential
Tomorrow we have division bench. Normally on Wednesdays we
matter? That's
go
why
for
Tuesday it should have been listed, my lord.
normally
Tuesday
on
and
Wednesday
Thursday.
we have division bench,
Yes.
and we have some fixed matters also tomorrow.
At least, my lord, we have come all the way. Let's see that we can do something.
No, I understand. So I mean, you should have made a mention for a fixed date on the last date.
Yes, my lord, that went wrong, my lord. So just, if your lordship kindly pass an order today, my lord, that as a last item, we'll make a try, my lord. If not, then we can at least fix the next date also to do with your lordship.
It's better to have a next date, Mr. Ziaul. I don't think you'll be able to do it.
That's true, my lord.
You pick up a date, any date
Yes.
you want, we'll give you.
Then I'll give it to the bench, my lord.
Okay.
We'll check if the mother
Yes.
diary, my lord.
You see what is convenient,
Yes,
date,
I understand
accordingly.
your lordship difficulty also, my lord. Much obliged, my lord.
For motion, item number 2.
Yes, my lord. I have just received the instructions this morning, and the instruction I have received is that the dispute review expert has not been appointed.
Sorry?
Dispute review expert has not yet been appointed.
Has not yet been appointed.
Yes, my lord.
So question is, why didn't you appoint it?
They are saying that it's up to the court to appoint.
No. Don't leave it up to the court every time. When you have an agreement signed between the parties, that in case of any misunderstanding or any kind of issue, this is the authority which should be appointed.
I will inform them again, my lord.
Then what else?
And the bank guarantee of rupees 81 lakhs 46,000 is already encashed in the account of the PWD department, and the rest rupees 28 lakhs 69,000 is not yet encashed. So it appears that the original BG
How much is the amount? Bank guarantees how much?
the total amount is
How much is encashed? Just tell me. Just now you said some figure.
81 lakhs 46,806.
Has been encashed.
Yes, my lord.
This is from what?
It's already encashed in the account of the PWD department. They have just given me these instructions and nothing else, my lord.
What is this amount?
My lord, if I may, it's a performance bank guarantee for which we submitted two performance bank guarantee, totaling of 1 crore 10 lakhs 16,280 rupees.
280.
Yes, my lord. The first
Performance bank guarantee.
Yes, my lord. One amounting to 81 lakhs 46,806, and the other one is 28,6,900. 28 lakhs 69,474. So the total of both the bank performance bank guarantee amounts to 1 crore 10 lakhs 16,280 rupees.
So 81 has been encashed.
Yes, my lord.
28 remains. What is your instruction on the interim stay?
They have no objection.
No objection for stay.
Yes, my lord.
You all had a meeting together? Both parties had a meeting out of court?
No, my lord, we have not met with the respondents.
I have informed them yesterday itself when the matter was called was unlisted, but they are saying that we have no objection with regards to the interim. I even sent them the photocopy, my lord.
Okay. Whose name should I record?
Both parties, both councils, my lord, if possible.
No, both councils are not recorded normally. Heard Miss Valentina Laldinpui, learned counsel for the petitioner, and Miss Caroline Kelung Oipui, learned government advocate, appearing for all the respondents. Stop. This matter was taken up on 21/10/2024, and court passed the following order. Please abstract. Next para. Today, Ms. Caroline Kelung Oipui, learned government advocate, submits that pursuant to the notice on final action dated 23/9/2024, a sum of rupees 81,46,806 from the performance bank guarantee submitted by the petitioner has been encashed and transmitted to the account of the State Public Works Department. Full stop. The learned government advocate further submits that as for the interim prayer made by the petitioner, the respondents do not have any objection. And that court may pass appropriate order as it deems fit and proper. Full stop. She further submits that in respect of the appointment of dispute review expert, the Department of Public Works also do not have any objection if the court directs that an appointment of an dispute review expert be. Please read that sentence. In respect of. You rephrase that, okay? The Public Works Department, from there you start again. The Public Works Department have no objection if a direction is made for appointment of a dispute review expert. Next para. Ms. Valentina Laldinpui, Learned Counsel, submits that a total amount of rupees 1,10,16,280 was deposited as performance bank guarantee by the petitioner. And after the encashment of some of the amount, there is a balance of 28,69,474 and submits that the same may be directed not to be encashed by the respondents pending final disposal of the writ petition. Next para. In view of above, let notice of motion be issued, returnable by 3 weeks. Stop. Since Ms. Caroline K. Lung Oipui, Learned Government Advocate, appears for all the respondents, no formal notice is required. Stop. However, the petitioner shall serve requisite copies of the writ petition to the Learned Government Advocate, if not already done. Stop. Having regard to the nature of the controversy, it is provided herein that till the next returnable date, the remaining performance bank guarantee, which has not been encashed as on today, shall not be encashed without leave of this court. Stop. Further, the ongoing process of invitation for bids (IFB) open tender dated 27/9/2024 which is due to be proceeded with by opening of the tender today at 2 p.m. shall remain stayed till the next returnable date. Full stop. it is also provided that the respondent authority concerned should appoint a dispute review expert to examine and look into the grievance projected by the petitioner. In terms of the provisions, relevant provisions of the contract data, as well as the conditions of contract entered between the rival parties. Some of the state respondents shall also file their counter affidavit on or before the next returnable date, so that the court can consider disposing of the entire writ petition by the next date. List this matter again on
My lord, in the last week of November.
You suggest a date when you can file? I said 3 weeks. So today is 22nd.
If it can be listed on 26th of November.
List the matter on 26th of November 2024, as paid for by the London Government Advocate. Stop. The state respondents shall file their counter affidavit on or before 19th of November with a copy to the other side, and the petitioner will be at liberty to file rejoinder affidavit within a period of 1 week from that date. Then you put the thing first at the last. List the matter on 26th of November. Okay?
My lord, in the meantime, if your lordship may allow the registry to give us the copy of the order before 2 p.m., my lord, we will have to furnish the order copy for the stay,
You can write a letter. See, you will get a copy.
my lord.
There's no issue.
Much obliged.
For orders, item number 8.
And government advocate, you also inform the department about this order, even before you get a copy. Yes, next item. Dika, one of you can type, go and type. One of you, not both of you. None appears for the petitioner, stroke applicant when the matter is called. For ends of justice, list the matter again after 2 weeks.
Item number 9.
Lordship.
Yes.
Lordship, I am appearing for item number 9 and 10.
We'll take up one matter at a time. Which
Lordship,
one do you want to take up first? 9 or 10?
Lordship 9.
9.
9.
Okay. So what is your case?
Lordship, my case is that my allegation was that by the excise, contraband, commercial quantity of contraband was recovered from the accused Manik Devnath, your Lordship, my client. And Lordship, after that, they were arrested and everything was done and charge sheet has already been filed. But Lordship, in charge sheet, there is no prayer for custody trial and they have
Just a
been...
minute. Where's that file? That motion matter? You've sent it. Should keep this in the file, okay? So my records. How much was recovered?
Lordship, some methamphetamine tablets of commercial quantity, Lordship.
How much?
Lordship, separate packet, 1 kg, 2 kg, such type of.
You don't know the amount?
Lordship, in seizure list, everything was separately seized and separately done, Lordship.
Even if it's separately done, what? Tell me the figure.
Lordship. Lordship, in total, your Lordship, 10 items were there, and Lordship, 983 grams in one item and 981 grams in another item.
983 and
981, Lordship.
981.
Lordship.
2 packets.
No, Lordship. These are the final packets. Lordship, there are 10 packets.
And the total weight is 983 plus 981.
No, Lordship, not total. Total weight was not mentioned here, Lordship, in the seizure list, Lordship.
So how do you say that it's commercial quantity when if you don't know the weight?
Lordship, in the Lordship, I have enclosed the copy of charge sheet, Lordship. Lordship, kindly see page number 2, Lordship.
Page number 2.
Page number 2, Lordship.
Page number 2 is not charge sheet. This is list of dates.
Lordship, sorry, Lordship. I beg your pardon, Lordship. Page number 16. Complaint page, Lordship, by the excise.
16.
Lordship.
So it says 9.782 kilograms.
Lordship.
Why did you say that you don't know the total? This is the total.
This is the total, Lordship.
Any other amount? Anywhere?
No, Lordship.
10 bundles
Lordship.
comprising of weighing 9.782 kilograms.
Lordship.
And it's basically orange colored tablets.
Lordship.
Quantity is 1 lakh.
Lordship.
So who are you?
Lordship, I am Manik Devnath.
No. What is your role in this case?
Oh, Lordship, from a vehicle.
You are driving that vehicle?
No, Lordship. Lordship, from the vehicle, my client Manik Devnath is a passenger, and from that vehicle, Lordship, that quantity of contraband was seized, Lordship.
What is your petitioner applicant's name?
Applicants Manik Devnath, Lordship.
Manik Devnath.
Lordship.
Now, vehicle is Bolero Neo N10.
Lordship.
Where is the registration number?
Lordship, this is not the vehicle of my client, Lordship.
Maybe. I'm just asking you the registration number of the vehicle.
Registration number. Lordship, Lordship, in the charge sheet, Lordship, the investigation agency, Lordship, did not enclose any documents relevant to this.
Where's the seizure list?
Lordship, seizure list is in page. Lordship, page 28, Lordship.
Vehicle did not have any registration number, it seems.
Lordship, Lordship,
Only engine chassis number is there.
Lordship, Lordship,
Bolero of white color.
Lordship.
So how many occupants were there in that vehicle?
Lordship, in the vehicle there were 7 or 8 occupants.
And who all were arrested?
Lordship, one of those passengers, my client Manik Debnath, was arrested, and another Ramchandra Das, he was arrested, Lordship.
Just 2%.
Lordship,
Only 2%.
only 2%.
And this this methamphetamine was recovered from where?
From the Lordship, I think from the inside of the vehicle, Lordship, but from where exactly was not written, Lordship, in the charge sheet.
Was recovered from the what is this? Redesigned compartmental box located on the floor pan of Bolero. On preliminary investigation, officer and team found that the person selling so and so was staying in the relatives in so and so,
Lordship,
reliable so and so. So then, you read page 18?
Lordship, page 18.
Yes,
Lordship.
paragraph 1.
Lordship,
Manik Debnath statement.
Lordship, Lordship. Lordship. Lordship, may I read, Lordship?
Yes.
Lordship, Manik Debnath's statement reveals that on 21st August 2023, he and Ramchandra Das had left for Aizawl from Agartala on the advice of Mahabur, reaching Aizawl on the same date at 9 p.m. Later on the same night, that is on 21st August 2023 at 11:30 p.m., they were instructed by Mabrul Mob to meet up with 2 persons at Langtepeng. On meeting them, they were handed over 10 bundles of methamphetamine, which they immediately hid the redesigned compartmental box located on the floor pan of the Bolero New N10. In the process, they were detained and arrested by the excise duty on the early morning of 22nd August 2023 at 3:45 am. Manik Debnath confessed in his statement that the seized drugs were supposed to be delivered to Mabrul Mob of Assam. He mentioned having made a mutual agreement with Mabrul Mob wherein he would earn rupees 15,000 for transporting the illicit items.
Then the other arrested person is Ramchandra Das.
Ramchandra Das, Lordship.
Who is the driver? Who was the driver of the vehicle?
Lordship, it was not mentioned who drive the vehicle.
You are the lawyer for the Manik Debnath.
Yes, Lordship.
You don't have any information.
Lordship, I am appearing for both the Lordship.
Yes, you are appearing for both.
Lordship.
You don't know who has driven the vehicle.
Lordship, in the record it is not found, Lordship.
No. You have not met with your clients also.
Lordship, their guardians have come to me, Lordship.
No, you must have gone. You must have gone and met them in jail to know the actual facts.
Lordship. Lordship, they have been in custody for more than 14 months, Lordship.
So, what is the stage of the trial?
Lordship, in trial, Lordship, some witnesses were examined.
How
Lordship.
many?
Lordship, 7 perhaps.
7.
Lordship,
And there are only 9 witnesses.
Lordship,
2 more to go.
Lordship. But Lordship,
Who are remaining? Who has not been examined?
Lordship, I think our investigation officer was not examined.
Serial number 9.
Your Lordship.
Ayo,
Your Lordship.
Benjamin,
Your Lordship.
and another person.
Your Lordship, another person. Your Lordship, 8.
Forensic.
Your Lordship.
Okay. When is the next court date?
Your Lordship, next court date is probably 24th.
24th of
24th
October.
October, Lordship.
Day after tomorrow.
Lordship.
So, what is the grounds
Lordship.
for bail?
Lordship, I humbly submit, Lordship. In this case, Lordship, Section 42 was seriously violated by the agency, Lordship. Whenever, Lordship, they received the information, Lordship, they did not make it as an GD entry, Lordship, they even did not inform to their superior officer also, Lordship. This is one of my ground I humbly submit, Lordship. And another ground is that, Lordship, whenever they prepare the charge sheet, Lordship, in that charge sheet, Lordship, no date of manufacture, expiry, etc. of those tablets, Lordship, methamphetamine tablets, nothing was mentioned there, Lordship. And in the charge sheet, in the seizure list also, Lordship, there is no specific time and date was mentioned, Lordship. Only whenever the officers put their signature, they mention their date after their signature, Lordship. These are, Lordship, my humble grounds, and inside of that, Lordship, Lordship, my clients are not involved in this, Lordship, and the investigation agency, Lordship, to shape up a concocted story, Lordship, they falsely implicated my clients, Lordship, in this case, Lordship. And my humble, with your kind permission, Lordship, I would humbly like to submit, Lordship, some judgment of Apex Court and Guwahati High Court, Lordship.
Yes, what are they?
Lordship. Lordship, first judgment is of Surija Vanu versus other state through Inspector of Police. It is the judgment of Your Lordship Apex Court. Your Lordship, Para 7 is relevant, Lordship.
Yes.
Lordship, with your kind permission, I am reading, Lordship. It is pertinent to note that in the bail application, the appellants, it was alleged that there was serious violation of Section 42 of the NDPS Act. In the impugned order, nothing is stated about the alleged violation of Section 42, and it is observed that it was not necessary to consider such violation at this stage. The compliance of Section 42 is mandatory, and that is a relevant fact which should have engaged attention of the court while considering the bail application. In the aforesaid circumstances, having regard to the special facts of the case, we direct that the appellants 1 and 2 be released on bail on executing a bond of rupees 50,000 each with 2 solvent sureties for the like amount to the satisfaction of the learned special judge and DPS, so and so, Lordship. And Lordship, my second,
Just a minute. Just a
Lordship.
minute. Yes, second case.
Lordship. Lordship, second is from Guwahati High Court, Mizoram bench in Lordship Lal Biankima versus the state of Mizoram. Lordship, that order was passed on 8/2023. Lordship, kindly see para 13 and 14. Lordship, may I read?
Yes.
Lordship, para 13. In the present case, from the materials available before this court, it is noticed that no such knowledge or information about the commission of an offence under the NDPS Act has been taken down in writing prior to arrest of the petitioner. The Constitution Bench of the Apex Court in Karnal Singh, while considering so as to whether Section 42 of the NDPS Act was mandatory or not, at paragraph 35D, held as follows. Paragraph 35D, while total non-compliance of requirements of subsection 1 and 2 of section 42 is impermissible, delayed compliance with satisfactory explanation about the delay will be acceptable compliance of section 42. To illustrate, if any delay may result in the accused escaping or the goods or evidence being destroyed or removed, not recording in writing the information received before initiating action, or non-sending a copy of such information to the official superior forthwith, may not be treated as violation of section 42. But if the information was received when the police officer was in the police station with sufficient time to take action, and if the police officer fails to record in writing the information received or fails to send a copy thereof to the official superior, then it will be a suspicious circumstances, being a clear violation of section 42 of the NDPS Act. Similarly, where the police officer does not record the information at all and does not inform the official superior at all, then also it will be a clear violation of section 42 of the Act. Whether there is adequate or substantial compliance with section 42 or not is a question of fact to be decided in each case. The above proposition got strengthened with the amendment to section 42 by Act 9 of 2001, Lordship. In my case also, Your Lordship, they did not note down when the information, secret information was received, and Your Lordship, they did even not give any copy to their superior. Lordship, later on, Lordship, when the contraband was recovered, everything was done, then also Lordship did not inform their superior officer. Lordship, this is my humble submission, Lordship.
Where is your allegation
Lordship,
to that effect?
Lordship, kindly see the complaint petition, Lordship. Lordship, page 23, Lordship, in the charge sheet.
No, in your bail application.
Lordship,
Have you made a statement?
Lordship, I made it, Lordship. I made it, Lordship. In my bail application, Lordship, it is mentioned, Lordship, in Lordship,
Page 5,
page 5, Lordship.
paragraph 4.
Lordship, paragraph 4.
So now you take into the chart sheet again.
Lordship,
Chart sheet starts from page 15.
Lordship, page 15, Lordship.
But page 15 will not contain all those things.
Lordship, after that, in page 20, from page 23,
Grounds
Lordship,
of belief, reasons
yeah,
recorded.
Lordship, one
This,
ground,
this will not be a part of the chart sheet.
Lordship,
It will be a part of the case diary.
Lordship,
It will be part of the case diary, but not part of the chart sheet. Because you have got only the chart sheet.
Lordship.
So what is there in the case diary, we don't know.
No, Lordship, in the charge sheet, what they submitted before the learned special judge, Lordship, that copy we received, Lordship, and in that, Lordship, grounds of belief was mentioned, Lordship, and in that also, in page 23, Lordship, the FIR,
See, you please come to page 23,
Lordship,
or what is this page number?
Lordship, page 23, Lordship.
23. There are two paginations. One is 23, one is page 8.
Lordship, page 8 is earlier, it is the pagination of learned special judge, Lordship.
You should have struck it out. It creates confusion.
Sorry, Lordship.
If there are 2-3 page numbers,
So I
then
would be careful, Lordship, next
you will
time.
say this page, I will say this
No,
page,
Lordship, I
and
will
we'll
be
waste so much time
Lordship,
in identifying the page.
Lordship, next time
Okay.
I will be careful, Lordship.
Page 23, come to that.
Lordship.
First paragraph itself, it says, recorded
Lordship,
grounds of belief.
grounds of Lordship. My humble submission before your Lordship is that, Lordship, whenever, as to the act, Lordship, whenever the information was received, Lordship, they first make an entry in GD entry in the PS or in their excise office, Lordship. Nothing was there, and that GD, Lordship, should be.
Please read before you submit.
Lordship,
Sir, I have the honor to report. Read.
Lordship. I have the honor to report that on 21st/8/2023 at around 8 p.m. Lordship, I received a reliable information from my source which stated that transaction of some amount of methamphetamine will take place at Shimui village. I reduced information in writing and submitted to OC ANS. I informed duty team as proceeded towards Shimui on the same night. After waiting for some hours, we detected one suspected vehicle without registration.
Without registration number
Number
plate.
plate.
So this is the one.
Lordship, I then invited reliable civilians from the locality of Simui. I conducted search on this 28/8/2023 at 3:45 a.m. Lordship, my humble submission is that, Lordship, in the FIR, if it is written by the agency or prosecution or investigation officer or complainant that I have complied so and so, this is not sufficient, Lordship. They have to produce whenever they receive the secret information. They first note it down, and the GD number was there, and that information was sent to his superior officer in writing, Lordship. Nothing was there in the charge sheet. Only a grounds of belief, Lordship. The grounds of belief,
That is why I pointed out the first time
Lordship,
that those are not part of the charge sheet.
Lordship. But
Charge sheet cannot contain all those documents like the contents of the case diary.
Lordship,
Whatever investigation has been done, whatever documents are required will be there in the charge sheet
Lordship.
to show that prima facie there's a case is well established under section 21C or whatever.
Lordship.
So, but whatever is the contents of the daily entries in the chart in the case diary, those are not usually part of the charge sheet.
Lordship,
I don't know whether
Lordship.
whether you used to see that in the charge sheet in other places.
Lordship.
We have not seen.
Lordship, I am from Tripura, Lordship. In our state also, Lordship, lots of cases are increasing under NDPS Act, Lordship. In our state, Lordship, whenever they receive the information, Lordship, they make a GD entry, and copy of that GD entry, Lordship, was immediately forwarded to the superior officer, and that copy, Lordship, copy and compliance of that to superior, Lordship, was included in the charge sheet. Simply, Lordship, 2 page. 1 page from GD extract, and another is a compliance letter to the SP or any gazette officer, Lordship. And whenever in trial, Lordship, we ask police officers sometimes.
So, if you say that it is not there, or if you doubt the contents, we can ask for the scanned copy of the case record if you want. We'll see
Lordship,
whether it's there or not.
Lordship may deem fit proper, Lordship. Lordship may desire. Lordship,
Because, see, this is not a small quantity. It's a case of NDNPS section 21C.
Lordship,
Almost 10 kilograms of
Lordship.
methamphetamine has been
Lordship.
recovered. And don't expect that the methamphetamine tablet will be like the normal medicine tablets, having date of manufacture, expiry date, company name. That will not be there. They're
Lordship,
simply tablets.
Lordship, without those, Lordship, without those, how can we believe, Lordship, that these are the contraband, these are the...
No doctor will prescribe you methamphetamine. You take 2 tablets of methamphetamine morning, 2 tablets at night time. Nobody will prescribe you.
Lordship.
So it does not come in a package form like that.
Lordship, that is why, Lordship, those guidelines were prescribed in the Act, Lordship. Lordship, I humbly submit, Lordship, my another 2 judgments, Lordship.
Yes.
Lordship, item number, Lordship, subject number 3 in the list of judgments, page 12, Lordship, para 22-23 are relevant, Lordship. It is from the Supreme Court. Sukhdev Singh versus State of Haryana, Lordship.
Paragraph?
Lordship, paragraph 22, 23, 24, 25, and 26.
Which one?
Lordship, Sukhdev Singh versus State of Haryana.
Okay, Sukhdev Singh.
Lordship.
Paragraph? Just repeat.
Lordship, paragraph 22.
22.
Your Lordship, page 12 of that judgment, Lordship.
This is also compliance of section 42.
Lordship, compliance. And Lordship, in that judgment, it was reiterated by the Apex Court that without that compliance, Lordship, conviction cannot be done. Lordship, I am reading para 22, Lordship. There is patent illegality in the case of the prosecution, and such illegality is incurable. This is a case of total non-compliance. Thus, the question of substantial compliance would not even arise for consideration of the court in the present case. The twin purpose of the provision of section 42, which can broadly be stated, are that it is a mandatory provision which ought to be construed and complied strictly, and compliance of furnishing information to the superior officer should be forthwith or within a very short time thereafter, and preferably post recovery. Lordship. Para 23, Lordship. Once the contraband is recovered, then there are other provisions like Section 57, which the empowered officer is mandatorily required to comply with. That itself, to some extent, would minimize the purpose of effectiveness of Section 42 of the NDPS Act. It is to provide fairness in the process of recovery and investigation, which is one of the basic features of our criminal jurisprudence. It is a kind of prevention of false implication of innocent persons. The legislature, in its wisdom, had made the provisions of Section 42 of NDPS Act mandatory and not optional, as stated by this court in the case of Karnail Singh.
In the NPS.
Lordship.
Yes. Yes. What
Lordship.
else?
And Lordship, my another judgment from the Supreme Court, Lordship, Robi Prakash versus State of Odisha. This is the Lordship order of 2023, Lordship. Lordship, in kindly see, Lordship, Robi Prakash versus State of Odisha. Lordship, in this order, Lordship, it's a small order. In this, Lordship, paragraph was not there in page 3 relevant, Lordship.
Paragraph is not there.
Paragraph, yes, Lordship.
It is
paragraph is there.
There are total 8 paragraphs.
Yes, Lordship. Lordship, in page 3, Lordship, it is mentioned that, Lordship, I am reading from para 2, Lordship.
Yes.
The prosecution case appears to be that the police party, while on patrolling duty so-and-so at about 12:30 p.m. on Nandapur so-and-so, spotted one fully body 12-wheeler truck bearing so-and-so coming from Nandapur site at a high speed, and accordingly they chased and detained the truck at so-and-so place and found 3 persons boarded in the said truck, including the driver. Eventually, 247 kg ganja was recovered from the truck. The petitioner was one of the occupants of the truck and was arrested at the spot. He has been in custody for more than 3.5 years. There are no criminal antecedents against the petitioner. Para 3, Your Lordship, we are informed that the trial has commenced, but only one out of the 19 witnesses has been examined. The conclusion of trial will thus take some more time. Para 4, Lordship, as regard to the twin conditions contained in Section 37 of the NDPS Act, the learned counsel for the respondent state has been fully duly heard. Thus, the first condition stands complied with so far as the second condition, that is formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b)(2) of the NDPS Act. Para 5, Lordship, however, we find some merit in the contention of learned counsel for the respondent state that the petitioner, being not a resident of the state of Odisha, some stringent conditions are required to be imposed upon him. Consequently, while directing that the petitioner shall be released on bail on his furnishing bail bond, satisfaction of the trial court is directed that he shall be required to produce 2 local sureties from the trial court. The petitioner shall also appear before the trial court on every date of hearing. In case he absents himself, it shall be taken as a misuse of concession of bail granted to him today by this court, ordered accordingly. Sir, Lordship, in this case also a long incarceration, and considering that, Lordship, Apex Court considered the bail application, Lordship. And same, Lordship, my last judgment, Ankur Chaudhary versus State of MP, Lordship. In this case also, Lordship, 2 years of incarceration. In page 4, Lordship. Oh no, page. In this case, Lordship, Lordship, from page 2, may I read, Lordship? Page 2, Lordship. Previous, Learned counsel for the petitioner submits that punch witnesses, that is PW3 and PW4, have been examined and they have not supported the case of prosecution. On being applied afresh, the trial court rejected his bail application only on the pretext that the investigation officer may also be a punch witness who has yet to examine. The High Court also rejected the bail application, affirming those findings by the impugned order. Learned counsel appearing on behalf of the respondent state submits that in the facts of this case, the investigation officer may be treated as punch witness. Therefore, the High Court has rightly rejected the bail application. Heard learned counsel for the parties. We have considered the facts and all attending circumstances, including the period of custody and also the previous orders, where this court, while rejecting the bail, was of the view that after the punch witness depose, fresh recourse may be taken. Now on examination, the punch witnesses have not supported the case of prosecution. On facts, we are not inclined to consider the investigation officer as a punch witness. This is to observe that failure to conclude the trial within a reasonable time, resulting in prolonged incarceration, militates against the precious fundamental right guaranteed under Article 21 of the Constitution of India, and as such, conditional liberty overriding the statutory embargo created under Section 37(1)(b) of the NDPS Act may in such circumstances be considered. In view of the above, we are inclined to allow this petition and direct to enlarge the petitioner on bail on furnishing the suitable bail bonds and sureties on such other terms and conditions as may be deemed fit and by the trial court, Lordship. In this case, Lordship, the accused petitioners were in custody for more than 2 years, Lordship. In my case, Lordship, I humbly submit, I am in the custody for more than 14 months, Lordship. Lordship. 22 of
So
Lordship.
1 year, 2 months.
Lordship, 14 months. Lordship, considering all these things, Lordship, on any condition, Lordship may kindly enlarge my accused petitioner on bail.
Okay, what about the other case?
Same, Lordship, my same submission.
Would you like to join it and same means
Same.
okay, same.
Same, Lordship.
Any more submission?
Lordship, no, Lordship.
Okay. PP?
Yes, my lord. What I would like to submit is that earlier the petitioner has submitted a bail application before the trial court. So, my lord, the judgment and order for that bail application is on page 104. My lord, if I may kindly take you to page 106, paragraph 4,
Yes.
if I may, my lord. Peruse the application along with its annexure as well as the case record. The seizing officer and investigating officer have been examined and cross-examined in the court, and their depositions show that seized contraband substances of commercial quantity were recovered and seized from the joint possession of the accused applicant, and that both applicants belong to the neighboring state of Tripura. Moreover, my lord, in para number 6, if I may, with respect to the alleged violation of Section 42 of the Act, it is seen that the information is reduced into writing and is submitted to the superior officer, that is, the officer in charge of Anti-Narcotics Squad (ANN) Aizol, who also countersign it on the same. The seizing officer is an ASI duly empowered by the state government under Section 42 of the Act, and his information report is duly submitted to his superior officer within stipulated time as per Section 42 of the Act, and the provision of Section 41 of the Act is not attracted in the instant case. So, my lord, it clearly stated that there is no violation of Section 41 as well as Section 42. And, my lord, it is seen that the case IO and the seizing officer were examined and cross-examined. And from their examination, it is clearly revealed that the contraband articles were seized from the possession of both the accused. And my lord, from the records, we can see that there is a conscious possession, since the seized contraband substances were seized from a specially designed hidden place from the seized vehicle, driven and boarded by both the accused.
Driven?
Both of them were inside the Bolero. Only two of them were there.
And no other vehicle, no other person.
No other person, my lord.
You said many persons were there in the Bolero.
Lordship, Lordship, I said because Lordship, in the charge sheet, Lordship, there was nothing, Lordship, mentioned that, Lordship, in the charge sheet or in any forwarding or in any report, Lordship. Nothing was there, Lordship, that only 2 was there. No, Lordship, nothing was there.
There's nothing there also which says that Mr. XYZ were
No,
in the
no,
vehicle.
Lordship, I beg
So?
your, Lordship, I beg your pardon. This is not that like that, Lordship. This, but as to the Lordship information which I received from the guardians of my client, Lordship, they informed me, Lordship. And Lordship, if there were separate persons, Lordship, they must be cited as witnesses in this case, Lordship. They must be cited as Caesar witnesses in this case, Lordship.
What does the charge sheet say
My lord, the charge sheet state that only 2
about
of
the
them were there.
occupants of the vehicle?
The occupants of the vehicle.
What does it say? Starts from page 15. We had read page 16 also.
On the 21st August 2023, Monday, at around 8 p.m., Ruth Lalwat Puyi, Assistant Sub-Inspector of Excise and Anti-Narcotic Squad, received report from undisclosed source stating that transaction of methamphetamine was to take place at Simui area. After recording information report, the officer and her team went to the reported area, and while performing duty, they suspected a particular vehicle at their site. After accumulating enough evidence, the officer convened reliable local civilian witnesses, and on complying mandatory provisions of law for grounds of belief as per under Section 42 of NDMPS Act, the officer checked the vehicle and she then seized the undermentioned articles. 9.782 kilograms. That is 1 lakh of orange color tablet methamphetamine kept in 10 bundles, with each bundles wrapped in a black polythene kept in a yellow and white polythene bag. Bolero Neo N10 off-white chassis number so and so, along with its ignition key and documents used for transporting the methamphetamine. In connection to the above seized truck and vehicle, she also arrested the possessor with below on the next date, that is 22 August 2023 at 3:45 a.m. on the roadside of Simui Bazaar. So both the accused name were written, my lord, and both of them were arrested at the same time.
What about there being any other occupants? Was there any
No,
other
my
occupants?
lord. Based from their evidence, it came in the light that the one accused person was there, who is the seller. He is the accused as well. But
He's arrested.
yes, from his possession they seize a certain amount, only the amount.
Who is
The
that?
sale proceed.
Who is the possessor of that?
Zonun Sanga, accused number 3.
Then what about Kopui Moya?
Kopui Moya, he is also in custody till now. All of them were in
Four
custody.
of them were
4 of
arrested?
them were arrested.
4 of them were in the vehicle, or what?
No, my lord. Accused number 3 and 4 were arrested based on the statement of both the accused, number 1 and 2. They revealed that the contraband articles were sold to them by Zonun Sanga.
Okay. And they were picked up from which place?
Edenthar.
Zonun Sanga.
Yes, my
Then
lord.
Kopui Moya.
From Edenthar, yes.
And the instant petitioner or applicant was arrested from which place?
Simui.
Simui. They were going back.
Yes, my lord.
They were going back with the methamphetamine. Okay, what else?
Yes, my lord. Another submission is that both of the accused were from Tripura. So if they were released on bail at this stage, there is a highly possibility of absconding and which will vitiate the trial. So it is humbly prayed that the bail application must be rejected at this stage.
Same submission for the other case?
Sorry, my lord.
The
Yes,
next
same
item-
submission. Same
Next
submission.
item also is
Yes, my lord.
similar.
Yes, similar case.
That's it?
That's it, my lord.
Any reply?
Lordship, may I submit a little, Lordship?
Yes.
Lordship, as my learned prosecution friend submitted that they are from Tripura and there is a chance of absconsion, Lordship. Lordship, it is not like that, Lordship. As your Lordship, this court, this honorable court, Lordship, enlarged so many people of Tripura, Assam, Lordship. And Lordship, in those cases, trial has been going on, Lordship. In my case also, if your Lordship kindly consider and enlarge my accused petitioner on bail, Lordship, strict condition may be imposed, Lordship. And Lordship, in this case, Lordship, already 7 witnesses were examined, Lordship. And Lordship, it's my humble submission, Lordship, I don't think that they will abscond. Why they will abscond? Because if they abscond, Lordship, process of court will be started and they will be again arrested, Lordship. So my humble submission, Lordship, may kindly consider.
Okay. Please write down. You are Mr.
Siraj Ali, Lordship.
Heard Mr. Siraj Ali, learned counsel for the applicant, who submits that. Okay, one more thing.
Lordship.
Ms. Vanesiami, you also. There's one order here passed by this court.
Yes, my lord.
Earlier, this is the second time they've come.
Lordship, earlier, Lordship, earlier when I approached before,
Before charge sheet, they submitted the bail application. And this
No,
court-
what I wanted to say was that there's an order from this of this High Court saying that if the one bail is rejected by a particular court, it has to be placed before the same court like that. So there's an order of dated 14/5/2024
Yes,
wherein the bail application was not entertained.
yes, it's not entered.
So will that be a bar for this court to pass an order? Huh?
no, Lordship.
Yes, my lord, it will bar. It has to go to,
No, it was not disposed of on merit. It says that first you should go and apply for bail before that.
Yes, Lordship.
yes,
Special
the
court.
trial
Yes.
court. Yes,
So it is not a disposal on merit.
yes, my
So
lord.
perhaps I don't think this should come in the way. All right, please write. Heard Mr. Siraj Ali, learned counsel for the applicant, who submits that by filing this application under section 483 of the Bharatiya Nagarik Suraksha Sanhita, bracket BANSS, bracket, comma, 2003, read with section 37 of the NDNPS Act 1985, the applicant prays for grant of bail. To stop, he submits that the applicant was arrested in the early hours of 22/8/2023 in connection with the recovery of um, ten packets containing 9.782 kilograms of suspected methamphetamine, which were in the form of 1 lakh orange-colored tablets. So the same was kept in a hidden compartment in a vehicle, Bolero Neo N-10 off-white, chassis number MA1NA 2XZX P6G89353, engine number XZP6G66567. Stop, the said vehicle was without any registration. number plate. Stop. The learned counsel submits that the applicant is innocent and has no involvement with the alleged recovery of the methamphetamine. To stop, he submits that charge sheet has been since filed by the investigating authority and trial has commenced. And so far, out of 9 prosecution witnesses, 7 prosecution witnesses have been examined. And the next court date is for 24/10/2024. To stop, the learned counsel submits that the applicant has been kept in custody since the last 1 year, 2 months, and therefore should be released on bail pending conclusion of the trial. Full stop. He submits that the investigating agency have grossly violated Section 42 of the NDNPS Act, since the information received was not recorded in writing and given to the next superior officer as mandated by law. To stop, he submits that the same is clear from the charge sheet itself, since there's no document which indicates that the same was complied with. To stop, he further submits that the charge sheet does not mention about the date of manufacture and the details of the recovered drugs, and therefore, without there being any such specification, the trial itself is vitiated. Stop. Since there is no chance for conviction of the applicant, he should be released on bail. Stop. In support of his submission, the learned counsel has relied upon the following authorities. Number 1, State Sarija Banu, bracket capital A, Janarth Hani and others versus State through Inspector of Police, 2004, legal, bracket SC 1187. Number 2, order dated 8/8/2023, passed by this court in bail application number 28 of 2023, bracket Srilal Biakkima versus State of Mizoram, close bracket. Next, Sukhdev Singh versus State of Haryana, 2012, legal, bracket SC 679. Then next, Rabi Prakash, RABI, Rabi Prakash versus State of Odisha, 2023, legal, bracket SC 697. And last, order dated 28/5/2024, passed by the Supreme Court of India in
Lordship, Ankur Chaudhary.
just a minute, in special leave to appeal, bracket criminal number 4648/2024, bracket Ankur Chaudhary versus State of Madhya Pradesh. Next para. Ms. Vanesiami, learned additional public prosecutor, on the other hand, submits that before coming to this court, the applicant has filed a bail application before the learned special judge NDNPS Act, and the bail application being bail application number 702 of 2024, along with 703 of 2024, were disposed of White Common Order dated 24/6/2024 by rejecting the bail application of the applicant and the other co-accused person. Stop. She submits that it is clear from the finding, from the reasons recorded by the learned trial court, that from a perusal of the deposition of the investigating officer and the seizing officer, the contraband substance of commercial quantity were recovered and seized from the joint possession of the accused applicants, and both the applicants belong to the neighboring state of Tripura. Full stop. It was further recorded that against the allegation of violation of Section 42 of the NDNPS Act, the court found that the information was indeed reduced in writing and submitted to the superior officer, that is the officer in charge, Anti-Narcotics Squad, bracket ENN, ISOL, who had also countersigned the same. Stop. The seizing officer was an assistant sub-inspector duly empowered by the state government under Section 42 of the NDNPS Act, and his information report is duly submitted to his superior officer within the stipulated time as per Section 42, bracket 2 of the NDNPS Act. Stop. Therefore, the provision of Section 41 of the Act was found to be not attracted, and that the twin condition of Section 37 of the NDNPS Act was not satisfied by the accused applicants, and accordingly the bail applications were rejected. Full stop. The learned additional PP therefore submits that it is clear that there is no violation of Section 42 of the NDNPS Act as alleged by the instant applicant, and therefore no ground has been made out for grant of bail. Full stop. She further submits that since the applicant is not a resident of the state of Mizoram, there is every likelihood of him absconding and the trial being vitiated. And trial being vitiated, you cut that. Every chance of him absconding and no likelihood of securing his presence at the end of the trial. Stop. She submits that under the facts and circumstance, the application of bail be rejected. Next para. I have considered the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Full stop. The fact not in dispute is that an amount of 9.782 kilograms of methamphetamine, bracket 1 lakh tablets of orange color, were recovered from the vehicle concerned, wherein the applicant was one of the occupant of the said vehicle. Stop. The investigation revealed that the same was obtained by the applicant from the other co-accused person who appears to be a resident of Myanmar. From the statements recorded, the other co-accused persons were arrested from which place?
Myanmar, my lord.
No, they were arrested from
Edenthar.
Edenthar locality. To stop. The statements of the applicant further reveals that they were sent by one person named, what is his name?
Zonul Sang.
No. Mabarul Mab from Tripura to collect the alleged drugs. To stop. Accordingly, the same was collected at a place called Leng Tepeng, wherein they were apprehended by the excise personnel. Section 37 of the NDNPS Act provides that in a case of such nature, the public prosecutor has to be given an opportunity to oppose the application for release of the applicant on bail. And on such opposition, if the court is satisfied that there are reasonable grounds for believing that the applicant is not guilty of such offense and not likely to commit similar offense while on bail, may consider release of the person on bail. Stop. In the instant case, the materials on record goes to show that the alleged drugs were recovered from the conscious possession of the applicant. Stop. The applicant, no doubt, has been in custody for the last more than 1 year. But at the same time, it is seen that the trial is proceeding at a good pace, since as many as 7 prosecution witnesses have been already examined out of the 9 prosecution witnesses cited. Stop. Moreover, the next court date has been fixed as 24/10/2024. Stop. Therefore, this court is of the considered view that the applicant should not be released on bail at this stage. Next para. Referring to the authorities cited by the learned counsel for the applicant, it may be seen that Sarija Banu, bracket capital A, Jannar Thani and others, Supra, as relied upon for violation of Section 42 of the NDNPS Act, will not be attracted in view of the observation and finding as recorded herein above. And likewise, the case of Lalbia Kima, Supra, as well. After Lalbia Kima Supra, you write as well, you cancel that. And Sukhdev Singh Supra as well. In case of Rabi Prakash Supra, the recovery made in that case was 247 kilograms of ganja, and the accused person who has been incarcerated for more than 3.5 years without him having any previous criminal antecedents. Full stop. It was also found by the Supreme Court that out of the 19 witnesses cited by the prosecution, only 1 witness had been examined. Stop. It was under such circumstance that the accused person was released on bail. The present case, otherwise, is not similar to what has been referred to. Accordingly, the authorities cited by the learned counsel for the applicant is found to be not relevant, and the bail applicant stands disposed of as rejected.
So kind of
Deeply obliged.
So similar order will be there in the other case, only the name will be different, isn't it? Okay. Item 10 also disposed, huh? 9 and 10.
For admission, item number 3.
Yes. What is this matter and why is it listed today?
Lordship, may I take a chance? Yesterday only I have filed Wakalatnama in this matter, item number 3, because it was handled by some other advocate, and for his non-appearance only I was given Wakalatnama. I have not received a brief. 4 weeks time may be given in this matter.
Which respondent?
NPCC.
NBCC.
NP.
NP.
Yes, my lord. National Project Construction Corporation.
Okay. What is the kind of work that it
My
does?
lord, I have no idea because I have not received the brief also. I have only filed the wakalatnama yesterday.
You are appearing for NPCC.
Yes, my lord.
What does NPCC do?
NPCC is a PSU, public sector undertaking.
It's a- okay. Construction?
my- Yes, construction.
You do
activities.
construction.
Yes, my lord.
So what is the difficulty today? The first time you're appearing.
I am first time appearing. I have filed wakalana. I have no brief.
You have no brief.
Yes, my lord.
But I see two thick briefs
No,
with you.
I have 5 matters today, my lord. I am going for other 4 matters. My lord, 4 weeks time in this matter.
Why 4 weeks?
My lord, I would have to study and file the affidavit and that is why.
Affidavit not filed.
Most probably not filed, my lord. They have said that they have not filed.
See, it took a great effort to compel the NPCC to appear before the court.
My lord, I am appearing for NPCC in other matters, and this matter was given to some other advocate. I am not naming the
We don't
advocate
know.
whatsoever,
See,
my lord.
We don't know which advocate will appear in which case, we don't know. But we are only interested that the party, whoever it is represented
Yes,
at the
ma'am.
appropriate time.
Yes.
So I was just saying that it was difficult to get NPCC present. On the last many court dates,
My lord, it has become.
they were not represented.
My lord, for PSU, it has become very difficult to get our fees also, my lord, nowadays.
Well, what to do?
Well,
Then
my
you will
lord,
have, then
that
they will
is
have to
the-
face the music.
My lord, that is a right concern, but at present, I am asking for 4 weeks time, my lord, for this matter only.
Mr. Ramzao?
Lordship, they have been absenting themselves from the proceeding. on
They have
number of
finally come now.
occasions. Yes.
But he wants 4 weeks' time to file affidavit and prepare.
Yes, my lord.
So I think we should give them one chance.
Yes, my lord. I would be.
But
very
don't
much
take it for granted
No,
that
no, I would never,
we'll
my
keep on
lord.
adjourning every time.
No, my lord, I would not.
With great difficulty, you have appeared today.
Yes, my
And
lord.
then make sure that you appear again next time also,
I
so
will
that we
appear,
can
Yes, my lord.
dispose it this way or that way.
Yes,
Isn't it?
Yes, my lord.
Today is 22nd. You're an outstation lawyer.
Yes, my lord.
You're
I'm from Guwahati.
So you suggest a date. I'll give you a date which is convenient for you. Provided you file the affidavit before you arrive. So that when you arrive, we can take up the matter.
My lord, I'm asking 4 weeks for filing the affidavit. So if we consider from that date, say by 25th of November,
Then what will happen? Mr. Ramzal, you might want to file rejoinder again.
May like to, depending on what they say.
So can we fix a timeline for that?
I think it's better.
A time for filing counter affidavit, a time for filing
Because
the reply
the
and a date.
consultation and everything, discussion they had.
It's
Only
all
thing
up
is
to you.
that they have not filed the affidavit. So I think even in other cases, they had made appearance, filed the affidavit, and I don't think that will take so long. Let the matter be fixed in the month of November. 1 week. I mean, he's praying for 4 weeks' time. Today is 22nd. Let it be fixed on 25th, 26th,
25th I have said.
25th.
Yes.
You file your affidavit by 18th of November.
Hello.
And within 1 week, Mr. Ramzao will file.
Yes.
Your good name, please.
P. Goswami.
Mr. Sheila Ramzawa, learned senior counsel, appears for the petitioner, while Mr. P. Goswami, learned counsel, appears for the respondent number 3 and submits that it is the first time that he is appearing for respondent number 3 today, and therefore he may be granted 4 weeks' time to file counter affidavit and to prepare the matter. So stop. In view of above, The respondent number 3 shall file the counter affidavit on or before 18th of November 2024, whereafter the petitioner may file a rejoinder affidavit within a period of 1 week, if so advised. Stop. As agreed to by the parties, let the matter be listed on 25th
25th on
of November 2024 for admission hearing.
Item numbers 4 and 5.
Lordship, this matter pertains to claim for payment of solicium and interest as provided under Section 23 of the Land Acquisition Act 1894. Lordship, the principal award, that is rupees 3 crore 28 lakhs 26,674 was paid and disbursed by the respondents on 6/10/2010. And at the time of making the awards, no such award in respect of solicium at the rate of 30% under Section 23, subclause 2, and interest at the rate of 12% under Section 23, 1A of 1894.
Okay, Mr. Ramsa, who's for the other side? You are there, Mr. Goswami?
Yes, ma'am.
Which respondent?
He is representing
Respondent number 5.
5. EPI.
Yes, my lord.
And what about the others? 1, 2, 3, 4.
1, 2, 3.
The state.
They have not filed any affidavit.
1, 2, 3, they are not file affidavit. But who's appearing? Nobody. Then number 4.
4 is CGC.
CGC.
Where is she? Where is our CGC?
She's in division bench, I suppose, my lord.
All right, we'll come back in 5 minutes' time. Please inform the other parties also who are supposed to be here, government advocate and the CGC. If it matter can be taken up for disposal, let parties be there.
Yes, ma'am.
My lord, I kindly beg your pardon. I want to make a mention. Morning I should have done, but I was little bit late. So can I just make a mention in item number 12?
Normally, it's not done like that.
Yes, my lord.
There's a time for mentioning, 10:30. What do you want?
My lord, I'm appearing on behalf of my senior. Due to the sudden demise of his close friends, he could not attend today. So,
Who is your senior?
Mr. Zauram Chana, for petitioner. We've already taken consent from opponent counsel also.
Mr. Goswami, you're here in this case?
Yes, my lord, I am for. Actually, she missed it. Immediately after Mr. Jiaul Kamar was, immediately the item was called, she missed it. She was sitting here also. So
What does this matter?
this relates to, my lord, land acquisition matter only.
Compensation.
Yes, my lord.
So when do you want it?
My lord, 25th, the other matter has been fixed. So,
November?
yes, my lord. Same day I can come. It would be convenient.
Mr. Caesaram Chana, learned counsel for the petitioners, is said to have some personal difficulty to appear before the court today, although the matter has been fixed on the prayer of the parties. Stop. Miss, your good name?
Lerwat Fili.
Miss Larwat Feli, learned counsel submits that the matter may be adjourned to a convenient date. Stop. Mr. P. Goswami, learned counsel for the respondent numbers 5 and respondent numbers?
One, two, three.
1, 2, and 3 submits that matter may be listed on 25th of November 2024. Since a similar matter is also being listed on that day. In view of above, let's list the matter on 25/11/2024 as paid for.
Much obliged. my lord.
All right.
Lordship,
Yes.
though CGC is not there, she's still on leg in the division bench. Lordship, matter can be proceeded on, the petitioner's case may be heard.
My lord,
Anything?
may I submit it, the matter is taken up by Mrs. H. Lamaswamy and she's on legs, my lord, in the division bench. With the CGC.
State is not
So-
filing affidavit and not contesting the case as such. The
Case is
role-
mainly
the role
between
is between the petitioners and respondents number 4 and 5.
4 and 5.
Respondent number 4 is the sanctioning authority in respect of the amount for construction of IBB fencing, and 5 is the agency.
So 4 has filed affidavit,
4 and 5 they have filed affidavit.
4 and 5 have filed.
Yes.
My lord, state should have filed because, my lord, in this, whatever the award has been paid in both the cases. Now, why they have not included the solatium and interest? The state should have said that, but state have not filed. The award amount has been cleared.
They should have done it. Why they have not done, they're not saying anything.
They don't say anything.
But today, if we find that solatium was not paid and solatium is entitled to them, then court will direct, make the solatium, calculate and pay. Simple as that.
No, my lord, there are other disputed questions also that I would submit once my senior friend.
Definitely, after hearing all the parties.
Yes, yes, my lord.
If they don't want to file affidavit, what to do? We cannot wait forever for them.
Yes, my lord.
You have no instructions, or you say that you will not file affidavit? I know you don't handle the matter, but at least there should be some understanding between the colleagues that
Yes.
I'm tied up with this matter. If this matter reaches, please submit in this manner or that manner. Otherwise, this will go on. Today, I'm hearing the parties here. The council will say in the other court that they are on legs there in that court. We don't know what has happened to this case. We don't know anything. So, only one court will function at a time. That cannot be. In the principal seat, so many courts are functioning. 15, 16 courts are functioning. And all the lawyers are being able to manage. So this practice should be adopted here also. You see, just because we have 2 or 3 courts, we cannot keep on waiting for each other like that. How long is the matter likely to last, that matter, on legs matter?
It's very hard to tell, my lord.
Okay, anyway, you pass the message. We're starting this matter.
Yes.
Let them come here once they've done. Yes, Mr. Ramzao.
Lordship, the
Mahat,
draft
you may
award
go.
number 3 of 2009,
Just a minute, Mr. Ramzao. Just come in. Yes, Mr. Ramzao.
may I take Lordship to page 47. It is a draft award number 3 of 2009, annexure 1.
How many petitioners are there?
Uh,
459.
459, yes.
There are 2 cases clubbed together. They are similar.
The other case, it's more or less similar in the sense that it's also in respect of the claim for payment of solicium in
No,
interest.
is it under the same award?
Not the same award.
Different award.
Different award.
2 different awards.
2 different awards.
So right now we are dealing with WPC number 75.
75, 2019, in respect of award number 3 of 2009.
Award number 3 of 2019.
9,
2009.
2009.
Just a minute, Mr. Ramzan.
Lordship, the lands of the petitioners located at Nakuk Sora, Bandia Sora, Saisen, Mauzam, and Mauzam villages. These are on the border. They were likely to be needed for construction of Indo-Bangla border road cum fencing. And the respondent number 2 made a notification under Section 4 of the Land Acquisition Act 1894 on 6/11/2006. Thereafter,
Indo-Bangla border road cum fencing.
Bangla border road cum fencing.
The road also is involved, not only fencing.
Yeah, both are.
Road as well as fencing.
Yes.
A notification was issued
On 6/11/2006 under Section 4 of Land Acquisition Act 1894. And the matter was processed and the petitioners submitted their claims and objections, and thereafter joint verification was conducted, and thereafter assessment of the compensation payable to the petitioners were made. And after completing the process, award number 3 of 2009 was made on 1st June 2010. Lordship, the draft award is there at page 47, 48. And the names of the petitioners.
The amount is 3 crores. 24 lakhs,
Yes,
27,000.
3 crore, 28
7.
lakhs. 328, Your Lordship. 26, 674.
Yes. So this award did not include
Solicium and interest. And the said amount, the assessed amount as per the draft award being approved by the state government was sanctioned by the respondent number 4, and it was given through the respondent number 5.
Now, when was the approval given by the state government?
Your Lordship, approval when it was given, but it was paid and disbursed on 6/10/2010. It was disbursed on 6/10/2010.
Approval date is not there?
Yes, my
Approval
lord.
date,
Annexer 2,
What is the date?
11th of May 2010.
Page number?
Page number
78.
78.
78, Annexure 2, isn't it? Okay. Now, solemnity and interest is under section 23(1)(a).
23. 23. Solicium is under 23, subclause 2, and interest under section 23(1)(a).
So, payment was done in 2010.
Lordship.
Why have you come here in 2019?
Lordship, in 2010, that payment was made. The petitioners, being the rustic villagers, not knowing their rights as to whether they are entitled to get solicium and interest over the amount which they have received, they did not know what to do. And in the meantime, in 2014, one Rupain Chakma had approached the Court of District and Session Judge at Lunglei, Judicial District Lunglei. Presumably on the basis of authorization made by those landowners. But when the matter was taken up, the landowners, through their respective village council presidents, they had made a protest that they did not authorize Mr. Rupain Chakma to do any such thing.
What did he approach? For what purpose he approached the?
Rupain Chakma had asked for payment of solicium and interest
By doing
by
what?
filing an application under Section 18. Section 18 application for reference.
2014, you say?
2014.
What,
And
and what is the case number?
it was
Reference number.
registered as LA case number 1 of 2014, but disposed of as LA case number 4 of 2014. So I think either of the two registrations, like 1 of 2014 or 4 of 2014. I think it's more of 4 of 2014 because the order, which is at page 79, will indicate. It is shown as LA case number 1 of 2014. The order at page 79, Lordship.
It says 1 of 2014.
Yes.
So from where do you get 4 of 2014?
Here, in the first para, this is the application for court reference under Section 18 of Land Acquisition Act, so and so. Award number 2 and 3 of 2009. Award number 1, 2, and 3 of 2009. Application has been registered as LA case number 4 of 2014. And accordingly, when it was disposed of, in view of the above, LA case number 4 of 2014 stands dismissed and disposed of.
Where was it dismissed?
It's brought by limitation.
Reference.
Reference was brought by limitation.
What is the limitation? 6 weeks?
6
6
yes.
weeks from
6 weeks
from the
date of
award?
knowledge.
Or 2 months from the date of knowledge? Something like that.
Yes, yes. And here, by this reference application under Section 18, all the awards, such as award number 3, 4, and 5 of 2007, award number 2 and 3 of 2008, and award number 1, 2, and 3 of 2009, have been put together by Mr. Rupain Chakma.
6 weeks if you were present when the award was declared, or 6 weeks from the date of notice from the collector, or within 6 months from the date of collector's award, whichever period shall first expire.
Yes. Your Lordship, during the proceeding of this LA case number 1 or 4 of 2014, the landowners, through their representatives, had also participated and submitted that they did not engage Mr. Rupain Chakma for the said purpose.
Anyway, it was dismissed.
Yes,
Whether they engaged
Since-
or not, it was dismissed.
since the matter was dismissed, this also reflected in the last para. During hearing of the case, objections were submitted by village council presidents of villages, the claimants, regarding authenticity of the power of attorney submitted by Rupain Chakma. However, I find that this issue need not be considered by this court at this stage. In view of the above, LA case number stands dismissed. So, this remains a closed chapter.
So thereafter, this writ petition in 2019.
We had filed a writ petition in 2016, writ petition number 150 of 2016. Your Lordship, at page 92, at page 92, annexure 5. It is writ petition number 150 of 2016. By an order dated 28/3/2017, we were allowed to withdraw the said writ petition with liberty to file afresh.
Where was it withdrawn?
Your Lordship, at page 92, at Mr. So-and-so, and 93, prayer in this writ petition pertains to solicium in interest at the rate of 30% and 12% as per provision of section 23(2) and 23A of the Land Acquisition Act 1894. Has the Lordship got it? At page 93.
My question was, why was it withdrawn?
Your Lordship, we had withdrawn because of the certain inaccuracies and because of the fact that in the meantime, another matter was taken up and reference was made in connection with that particular case. Reference case number 1 of 2017. Your Lordship may see at page 94. This is a case which was espoused by Young Lai Association against the state of Mizoram.
Before that, Mr. Ramzawa, please come to page 93. Second paragraph. What number 3? It says a detailed order was passed earlier in this regard on 14/2/2017. What is this? Who passed the order?
Detailed order.
That is one thing. Second thing is the writ petitions are dismissed as not pressed.
Yes.
Why?
Because what we had sought for, though it was under section 23, subclause 2 and 23, subclause 1A. In the meantime, the matter, similar matter was adjudicated by the Honorable Court in the division bench, in which Your Lordship had also sat as one of the judges. Your Lordship, in this case, since this judgment was there, and since nothing about what has been stated in the order, judgment and order dated 24/4/2017 was made.
Reference case of 1 of 2017 was a reference made by which court?
Reference from the single bench of this Honorable Court. A lot of perusal of this later, the judgment and order at page 95 will clearly indicate. May I take Lordship to page 95?
Yes, I'm already there.
Yes.
Whether writ petition claiming interest in solicium under LA Act, which power vests
Yes.
with the reference court, is maintainable in absence of any reference being made by the court.
Yes. And that too, when the petitioner has already accepted the awarded compensation. This was the issue that was referred.
I think the decision was yes, it is maintainable.
Yes.
Writ petition claiming interest and solicium under so and so, even in the absence of any reference, would be maintainable. So, what is the order date of the reference? Paragraph 4. Question which has been referred to us for decision is as under.
dated 19/8/2015. Para 5. May I read para 5, Your Lordship?
Five. Okay, 19/8/2015. It's okay. So, this is the reference, this is the order. I think
Yes, yes.
there's no requirement to read that. Now, thing is that you have come to the court through WPC 150 of 2016, but you decided to withdraw it with liberty to file afresh.
Yes.
And is it because of this reference?
This issue was there, but it was not yet decided at that point of time.
Huh.
And now, because certain formal defects were there in the writ petition itself.
There were defects.
Yes,
Otherwise, you could have just waited for the outcome of the reference, isn't it?
That's true,
Instead of withdrawing it.
yes,
But there were some defects in your writ petition.
Yes.
So you had to withdraw it. So after withdrawing this WPC 150 of 2016, now you have come again with this present writ petition, is it?
yes.
Is there anything in between?
Nothing in between.
Okay. So your basic claim now is give us the solatium in interest.
Yes, Your Lordship. That's the main thing. Solatium and interest, because this is the statutory right of the petitioners, and even if the limitation under section 18 as already held in that particular case, 1 of 2014 or 4 of 2014, though it has barred the claim of the Mr. Rupan Chakma on behalf of the petitioners. But though the petitioners did not authorize Mr. Rupan Chakma, the matter remains the same because it was closed, dismissed as barred by limitation. So the issue now is whether the landowners who were awarded compensation on the basis of the draft award which was approved by the government, whether they are entitled to payment of the solatium and interest as provided under the said sections of law, even though they had accepted the awarded amount. So the reference was answered in the positive by the division bench of this honorable court.
Acceptance of the award cannot be the bar to get solatium in interest.
That's true.
I think so. Just because you accepted the award
But
as it was.
under section 18 of Land Acquisition Act, it has to be under protest. It has to be received under protest and all that. But since that section 18 is not invoked at this stage, the question of whether it is accepted or it has been received without any objection or whether with objection, that does not matter.
No,
It is the
see,
statutory right of the petitioners.
correct. Solatium in interest is a part and parcel of the
Yes.
award. Now, regarding section 18 reference would refer to a case wherein you are not happy with the award, wherein the market value has been fixed, which is lesser than your expectation,
Right.
considering the market value of the land in and around your land, you have been given a lesser amount. So that is where you go for reference. Say that,
Yes.
please increase the market value. But interest, solatium and interest is a different component. Solatium and interest is a part and parcel of the award. Market value is a different thing, for which you need to file reference to upgrade your market value.
That's true.
But for solatium and interest, I think the reference court has answered it, say that you cannot deny. Merely because he has not filed section 18 reference application requesting for solatium and interest, you cannot be debarred from getting that. It would be a different question altogether if you are asking for enhancement of your market value. In that case, reference of section 18 will be required.
Right.
Unless, of course, if somebody had approached this court, or approached the reference court for enhancement of the award, and he has got that benefit. You have not filed the reference application, but somebody similarly placed has got that benefit. Even then, you can also apply, saying that you have already calculated. I am a neighboring landowner. I should be getting that rate. That also is applicable.
That's true. Under 28A.
Correct. So, but today your case is regarding solatium in interest,
Solatium interest.
whether it should be given or not. I think the issue is limited to that extent
Yes.
only. Do you have any other decision apart from this reference court's decision on solatium in interest?
Your Lordship, similar matter was decided by this honorable court, and that was in a case of Jogadish and others in WPC number 156 of 2017. In which Lordship was the presiding judge of this honorable court in WPC 156 of 2017. Even here, following the judgment of the division bench, Lordship had passed this order allowing payment of interest and solatium, as well as interest in terms of Section 34 of Land Acquisition Act, may I take Lordship to page para 4?
Para 4, yes.
Appearing for the petitioners, Mr. R. Malhotra, Learned Counsel submits that after a claim of the petitioners in WPC number 119/2015 for payment of solatium interest was referred to the division bench. Division bench, after registering reference case number 1 of 2017, white judgment and order dated 24/4/2017, held that the petitioners will be entitled to solatium interest under Section 23(1)(a) and Section 23 subclause 2 of LA Act. Entitlement will subsist even without a reference under Section 18 of the LA Act. After the reference was answered in the above manner, the writ petition were on being remanded back to the writ court. The same was decided in favor of the petitioners, by judgment and order dated 22/2/2018, holding that the petitioners will be entitled to solatium and interest in addition to the already awarded sum. Thus, the Learned Counsel submits that the petitioners are again before this court in view of the decision taken by this the division bench in reference case number 1 of 2017, and also the consequential order passed by the writ court, white judgment and order dated 22/2/2018, as in WPC number 119 of 2015. He submits that the petitioners being similarly situated, court may direct the respondent authorities concerned to award solatium and interest to the petitioners as well. Further, in addition, interest in terms of Section 34 of the LA Act may also be paid to the petitioners. The objections Mr. A.H. Barbuya, a Learned Counsel appearing for respondent number 4 and 5, submits that in the event circumstances,
It should have been given circumstances.
in the given, yes, if the petitioners are entitled to payment of solatium and interest, the same may be considered and paid to the petitioners as per the provision of law. Insofar as the claim for interest under Section 34 of the LA Act respondent authorities concerned may be directed to consider the case of the petitioners and thereafter to pass appropriate award if it is found that the case of the petitioners are covered under the said provision of law. Mr. Rosang Zola Ralte, learned government advocate, submits that insofar as the collector is concerned, the award deposited by respondent number 4 and 5 has duly been disbursed to the concerned claimants. As for the solicitation and interest and payment of further interest in terms of Section 34 of the LA Act, the same may be left to the collector concerned for necessary consideration and passing of an appropriate award. I have heard the learned counsel appearing for the rival parties, and I have perused the materials available in the court, including decision rendered by the division bench in the reference case, and also the order passed by this court on 22nd February 2018. On such perusal, it is only apparent that the case of the petitioners are covered by decision rendered to referred to above. In that view of the matter, the writ petition is disposed of with direction to district collector, respondent number 3, to make an assessment of the solicitation and interest entitled to each of the petitioners for acquisition of their land in terms of award number 2 of 2009. While making such assessment, the district collector shall also determine the entitlement of the petitioners in terms of Section 34 of the LA Act and thereafter pass a concise and consolidated award on entitlements of the petitioners therein. Such exercise should be done as expeditiously as possible and within the outer limit of 2 months from the date of receipt of the certified copy of this order. On such determination and pronouncement of the award, respondent number 4 and 5 shall process and deposit the award amount within a period of 3 months from the date of receipt of the award from the collector. With above observation and direction, writ petition accordingly stands disposed of as allowed. Your Lordship, there is a similarity in all aspects except the names, the amounts, and all that. Your Lordship. The reference case, which was decided by a division bench of this honorable court, was applied even here. And, Your Lordship, this judgment was challenged by the respondents 4 and 5.
Which judgment?
Respondent number 5.
Which judgment?
The
one which you just
Yes,
read out?
The one which I have just read out.
Okay.
In the Supreme Court by filing SLP.
Okay.
And the matter
then?
was pending for quite some time. Lordship, finally, on 4/1/2024, decision was made by the Apex Court.
It was challenged by 4 and 5.
5, in fact.
Okay.
Lordship, from the cause title, Special Leave Petition number so and so, arising out of the impugned final judgment and order dated 8/11/2018 in WPC number 156 of 2017, passed by the Aizawl bench of Gauhati High Court. It was at the instance of NPCC, National Projects Construction Corporation Limited versus Jagadish and others. It was filed in 2019 and by an order dated 4/1/2024, the matter has been brought to an end with the following order. Upon hearing the counsel, the court made the following. Number 1, we are not inclined to interfere with the impugned judgment and order passed by the High Court. The special leave petition is accordingly dismissed. 2, pending applications, if any, shall stand disposed of. So, with this short order, the Apex Court declined to interfere with the judgment rendered in this WPC 156 of 2017. So, in view of what has been decided by this honorable court in the other case, and which has been taken up in the Supreme Court by the aggrieved party, that is NPCC. Lordship, when the matter was dismissed and when the Apex Court refused to interfere in the matter, what is now standing and what is now holding the field is the judgment, the order dated 8/11/2018, which is based upon the judgment and order passed by the Honorable Division Bench in the said reference case. So, taking into consideration the facts and circumstances under which the instant petitioners are seeking for their remedy for payment of solicium and interest as a statutory right given by the law. The question of the claim of the petitioners being barred by limitation will not arise, though they had approached this Honorable Court in 2019, and they had earlier approached the Honorable Court by filing the said writ petition, which was withdrawn with the permission of this Honorable Court. So, in fact, there is no lapses on the part of the petitioners. And now what they have sought for is for payment of the same benefit, that is interest at the rate of 12% under section 23(1)(a) and solicium under section 23(2) of Land Acquisition Act. Lordship, as also the interest under section 34 has not been specifically mentioned here in the writ petition. However, even in the earlier case, though interest under section 34 was not specifically mentioned, Lordship had exercised the discretion under the 226 of the Constitution of India and had awarded and had in fact directed the authority concerned, that is the DC of Lunglei, to consider as to whether 34 should also be paid. And finally, it was assessed. However, till date, Lordship, it may be seen in the other case where contempt is filed, no such payment has been made till date. And contempt is being filed. Contempt is,
In which case?
in the Judamuni. Item 6.
In which case?
Item 6.
Okay. This is also related to this matter?
Yes, this is related to this Jogadi. Yes.
Judamuni.
Judamuni. Judamuni is one of the petitioners there
In which case?
in that Jogadi's case.
Jagadi's case.
Yes. That
Wherein the Supreme Court,
156 of 2017.
wherein Supreme Court didn't interfere, that judgment.
Ah.
So in view of
This petitioner number 2296. Judamuni. Petitioner number 296 in WPC 156 of 2017.
yes 296.
296. Judamuni. So, the order of this court was challenged in SLP.
Yes.
SLP is disposed in January, 4th January. So, contempt also should be considered in that line.
That's true.
Anyway, that's basically your case, isn't it?
Basically, yes.
You have received the amount of compensation, but not the solatium in interest. Somebody had filed in your behalf before the Lunglei court, which was dismissed because of delay in view of the stipulation under section 18. Then you came again before this court, again you withdrew that because you said there was some discrepancy or there was some mistake in the writ petition. Same time, there was a reference made by the writ court where the solicitation can be claimed by way of writ petition without filing section 18. It was answered in affirmative. The writ petition was disposed of, taken to Supreme Court, it was dismissed. So you should get the same benefit. That is your
Yes,
case.
yes, that's the case.
Okay. We come back at 2. We'll hear the other side.
Next, then you sit.
Lordship, since this item number 4 and 5 have been placed together, Lordship, I'll just take Your Lordship to the facts of this case, Citrosen, WPC number 76 of 2019. Your Lordship, this is in connection with the word number 3 of 2007,
Which case?
Citrosen, serial number 5. That's up the draft award number 3 of 2007 is at page 54. This also in respect of acquisition of lands for construction of Indo-Bangla border, road cum fencing, implemented by EPIL along Indo-Bangla border road within Lunglei district. Award number 3 of 2007. Petitioners 552.
Yes.
And notification under section 4 was made on 6 November 2006.
Same thing.
Same thing, yes.
This is also Indo-Bangla border road cum fencing.
Yes, Your Lordship. And award was pronounced on 12 October 2007. 12 October 2007.
Yes.
The awarded amount comes to 699 crore 66 53,019.
Just tell me the figure. 6
Not 6, Your Lordship. 966
966
53
53
019.
019.
That amount was disbursed to the landowners, petitioners on 9/4/2008. And the principal award, which is 966,53,019, was without interest and solution.
Yes. Any case filed earlier?
Your Lordship, approval of draft award was on 2/11/2007. 2/11/2007. And this was also connected with LA case number 1 of 2014 at Lunglei. And it's covered by the same order dated 18/9/2014.
Dismissed.
Dismissed. And thereafter, Lordship, the earlier writ petition in connection with the instant writ petition was filed under WPC number 146 of 2016. 146 of 2016. And the same was allowed to be withdrawn with liberty to file afresh on 28/3/2017 by the order of this Honorable Court.
Which is that page?
At page 113.
In the Lunglei case
Lunglei
order
case
at page
at page
100, I think.
100, 102, 102.
So a lot of cases were dismissed. Award
Yes.
number 3, 4, 5.
Yes, all these cases indiscriminately filed by one Mr. uh, Rupain Chakma. In fact, on the basis of a complaint, FIR, made by one of the village council presidents, the petitioner, Rupain Chakma was booked under section 468/472 IPC. And he was charge sheeted.
Okay.
White charge sheet number 1 of 2015 at page 110, Your Lordship. Then comes the reference case number 1 of 2017 at page 115.
The rest is same.
Rest is same. Yes.
So we can hear the other side now, Mr. Ramza.
Why not I start with the 75 Luzon? 75 of 2019. Item 4.
Yes.
Why not the draft award amount, that is 3 crore 28 lakhs 26,674. Entire amount is paid, and that has been admitted by the petitioner in para 6 of writ petition.
Yes.
Yes, why not? Now the question is, where is the aggrievedness, my lord, for writ petition? Because, my lord, I have not seen any representation put up before the deputy commissioner in this brief. To invoke 226, my lord, there is no representation before the deputy commissioner, because award is being paid. This is a fresh cause of action for solatium and interest that has been brought directly either to the reference for by way of section 18 or here in writ petition. My lord, I come to the prayer before going to the merits. I come to the prayer, my lord, of
Yes.
this in
Page 45.
page 45, my lord. I read out the prayer, my lord.
Yes.
In the premises, it is most humbly prayed that your lordship may graciously please to admit this petition, call for the records and issue rule calling upon the respondent to show cause as to why impugn order dated 89/14 passed by the district and session judge Lunglei Judicial District, Lunglei, in LA case number 1 of 2014 shall not be set aside and quashed, and why the respondent shall not be directed to give solatium at the rate of 30% and interest at the rate of 12% per annum in accordance with section 23 1A and 2 of the LA Act 1894 for acquiring the lands of the petitioner by way of draft award number 3 of 2009. So, my lord, basically in this petition, the petitioner has sought for quashing of the judgment of the Lunglei District Court by District and Session Judge by way of this writ petition. So, my lord, as per my humble understanding, they should have gone for appeal against that order, not by way of writ petition. And coming to the other part, solatium and interest, I will come, my lord.
Appeal against the award.
Yes, appeal against that.
Why?
Because, my lord, that appeal has decided that it is barred by limitation and they have dismissed the appeal. So, if there is anything against that judgment, otherwise it would be a floating judgment, my lord. Until and unless this judgment is quashed by way of this writ, if the writ has the power, if it is quashed, it is fine. It is okay, my lord. But otherwise, it would be a floating judgment.
What do you mean by floating judgment?
I mean to say, my lord, that would be a judgment wherein one court has decided that this reference is not maintainable because of limitation, and writ petition has decided that that solatium and interest can be paid. Now, coming to solatium and interest, that I am coming, my lord. This is my submission only, that they didn't go for appeal of this judgment, against this judgment. My lord, may I request my lord to come to award number 3 of 2009, that is 47 of writ petition.
Now, before that, please come to page 79. Why was this LA case filed? For what? Solatium and an interest.
Yes, my lord.
Okay.
And my lord, the reference judgment, I am corroborating the reference judgment which has been put by the division bench where my lord was one of the author. If my lord see page 95, the question
Yes.
in para 4, whether a writ petition claiming interest and solatium under Land Acquisition Act of 1894, which, this is very important, my lord, which power vests with the reference code under 23 1A and 2 thereof, is maintainable in the absence of any reference being made to the court in terms of section 18 of the Act, and that too when the petitioner has already accepted the awarded compensation. So, my lord, in this case, if we read between the lines, my lord, it says, in the question itself says that power vests with reference code.
So let us see 23.1A, 23.2.
My lord, may I read? 1A?
Yes.
In addition to the market value of the land as above provided, the court, the definition of court is there in this book, shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of publication of the notification under section 4, subsection 1, in respect of such land to the date of the award of the collector or the date of taking possession of the land, whichever is earlier. So, my lord, the court itself goes to principal court. If we see the definition,
Code means what code? Reference code.
My lord, it is in 3D. The expression for 3D, section 3D, my lord. My lord has got it.
3D.
3D, my lord.
Yes, expression code.
The expression court means a principal civil court of original jurisdiction. Under the appropriate government has appointed, as it is hereby empowered to do, a special judicial officer within any specified local limits to perform functions of the court under this act. So it is the district judiciary only, my lord. So this reference, suppose they don't go for reference to district judiciary, then they can come here.
They had gone there, but it was rejected.
That was
so
rejected.
why should they come now in writ petition?
Yes.
When the judgment of the reference court is still subsisting.
Yes, my lord. So they should have gone for appeal.
Appeal under what provision? LA appeal.
LA appeal. Right, my lord.
But they are seeking for setting aside that order also.
My lord, now coming to why WPC should not be entertained, because there are disputed question of fact.
Like?
My lord may see this award, page 49 of WPC.
$49.
Sorry. It starts from 47.
47. Draft award 3.
Yes, my lord. My lord, I have read it one by one, all lines. There is no whisper, my lord, as to how much land has been acquired. Nowhere. Neither in compensation statement, neither in this award.
So on what basis the calculation is made?
That is what I would come that, my lord. My lord, section 11.1, what it says, my lord. Section 11.1 of the LA Act.
Yes.
On the day so fixed, or any other day to which the enquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated, pursuant to a notice given under section 9 to the measurements made under section 8, and into the value of land at the date of publication of notification under section 4, subsection 1, and into the respective interest of the person claiming the compensation, and shall make an award under his hand of the true area of the land. Number 1. That is not there, my lords. The compensation which in his opinion should be allowed for land. This also I would come, my lord. The apportionment of the said compensation among all the persons known or believed to be interested in the land, of whom or whose claim he has information, or whether or not they have respectively appeared before him. So, my lord, this apportionment is also not there. What is the land value? What is the building? Value of building? Nothing is there, my lord. My lord, I come. Why did I pay? Question is, why did I pay the amount? Because, my lord, if my lord goes to page 49, page 49, my lord, that is the assessment of compensation. My lord has got it, my lord.
Yes.
My lord can see if in this table 1, 2, 3, 4, 5, 6, and 7 columns are there. In the 5 and 6 column, mainly, my lord. It is amount claimed and amount paid. Whatever the amount has been claimed has been paid. no fixation of market value. That I would come why solatium and interest cannot be calculated, that also I would come. Because solatium and interest as per section 23(1)(a) has to be calculated on market value. This is the amount claimed and amount paid. I have paid because these are the person interested. Whatever has been claimed, that has been paid. My lord, even approval is of less amount, but I have paid the entire amount. If my lord see the award value is 3 crore 28 lakhs 26,674.
28 lakhs.
3 crore 28 lakhs. My lord, it is in 48, page number 48.
No, I was told 24 lakhs. 27,674.
No, my lord would come to page 48.
48.
This is the
328.
figure, 3 crore 28, 26, 674. It consists of 21,000 as administrative cost. So, my lord, if my lord see the approval in Annexure 2,
So administrative cost doesn't go to the landowner.
no, it doesn't go to landowner, but I am telling my lord, even if we consider 3 crore 28 lakhs, the upper figure minus the 21 lakhs, 21,000.
Three 28, 26, 674.
So now, my lord, if my lord comes to page 78, approval,
Yes.
there is a disparity in the figure also, my lord, with reference to the above. I am reading, my lord. I am directed to convey herewith approval or government on draft award 3 of 2009 for acquisition of land for construction of IBB fencing amounting to 3 crore 24, 27, 674. Only excluding 59,682 only, which was assessed for land value of 16% of Bandisora, Humundu, as village council passes not admissible to get land value. So this approval is for 3 crore 24, 27, 670. My lord, how much my lord does arithmetic? It is not going to tally, my lord. That I tried. Even if we compare with 3 crore 28 lakhs, then if we reject 56,000 also, 59,000, then also this 3 crore 24 lakhs doesn't come, my lord.
There's a difference of 3,99,000.
Yes. Whatever it is, my lord, there is a difference.
Amount awarded and amount approved.
Yes, my lord.
Approved is lesser.
Lesser.
3,99,000.
Even if 59,000 which has been stated there, that is also deducted from my award figure minus the 21,000 administrative cost, then also this doesn't come.
Now, coming to the calculation of solatium, You say that the market value has
Yes,
to be
my lord.
there.
I'm coming to my lord 23, 1A and 2 of LA Act.
Twenty-three, one and two.
1A.
1A.
Yes, my lord.
Yes.
In addition to the market value of the land, as above provided, court shall in every case award an amount calculated at the rate of 12% per annum on such market value, again market value, for the period commencing on and from the date of publication of the notification under section 4, subsection 1 in respect of such land to the date of award of the collector or the date of taking possession of the land, whichever is earlier. My lord, I am not reading the explanation part. I am going to 23.2. May I read, my lord? 20.
Yes.
In addition to the market value of the land as above provided, court shall in every case award a sum of 30% on such market value, again market value, in consideration of compulsory nature of the equation. My lord, why there is no market value? The state has not given affidavit, which I said that state should have given an affidavit. Because, my lord, if my lord see this compensation statement, my lord would have a better understanding of Mizoram Land Act. What I have read, my lord, that these are all pass holders, village council pass. And as per my lord, Section 211 and 5 of Mizo District Land and Revenue Act 1956. My lord, 211. May I read, my lord?
Yes.
Pass holder means a person who has the temporary right of use and occupancy over a specified plot of land for a specified period under such terms as the administrator may prescribe in the pass he holds. So, my lord, it is a temporary right of use. They do not have right title interest, pass holders. Here in all are pass holders, if we see the compensation statements. And my lord, if we see the 5, right of pass holder, section 5 of the same act, my lord. In page 3, my lord. A pass holder, may I read, my lord?
Yes, yes, read.
A pass holder shall have no right in the soil beyond right of user for the period for which it is given, and shall have no right of transfer or of inheritance beyond the period of the pass or for subletting. The same thing is again repeated, my lord, in section 21(3) of the new Mizoram Land Revenue Law. This, in my, not whatever I have understanding, my understanding, this should not become applicable because this is 2013 Act. And this land has been taken for public purpose in 2010 itself. So, but it is again, it is repeated here in 21(3) and 27 of Mizoram Land and Revenue Act. If my lord has the act, I can again.
It's okay. Is it required? You
Not
yourself.
required, but it is like government is on the same standing that pass holder doesn't have any right. And even the approval, some portion of the approval amount was deducted because pass holder shall not get compensation. That they have stated.
Where?
But if we see in the approval that 59,000 has been deducted, Annexure 2 at 78. Village council pass, last line, my lord. Village council pass is not admissible to get land value.
Have they been identified? 16 persons. Who are they?
My lord, that detail I don't have. But if we see, my lord, everything in the heading itself up in page 49.
It just says pass number.
My lord,
It just says pass number.
pass number.
It does
But
not.
in the other case, the other item number 5, there into 3 areas it is written as LSC by hand.
By hand.
Yes, my lord.
So all these figures are pertaining to pass.
Pass. That is why whatever has been claimed has been given, my lord.
Let us see what does it say. The introduction, location of land, assessment and compensation.
Lordship, under location of land and nature of passes, it has been clearly provided that location of land, building, crops and properties is along Indo-Bangladesh border within radius of so and so, point of international boundary towards India's side, and passes in respect of LSC and Pipata were issued by Land Revenue and Settlement Department, Government of Mizoram, and passes in respect of houses were issued by Village Council authorities as provided under Section 1 of Section 3, Lusai Hills District House Site Act 1953, which is deemed as good as LSC, issued by Land Revenue and Settlement Department.
Deemed.
Passes in respect of houses were issued by the village council authorities. So
These
long
are
as
passes, my lord. I have read this. They have given a comment that it is deemed as good as LSC.
the village council has the authority to issue house site pass and not for agriculture purpose. So it says that once the pass has been issued for the house and people are residing there and under occupation, it is as good as any other pass.
That is their statement, my lord. But they have not calculated they have not given the figure. Whatever has been claimed has been given. No market value.
The first paragraph, third subpara of first paragraph, it says, as many as 536 claims were received. Joint verification of claims was conducted, and 526 numbers of claims were accepted. An assessment of compensation on land, building, crops, and properties was made.
Yes, my lord.
Compensation on
Claims
land.
were received, joint verifications of claims was conducted, and 526 numbers of claims were accepted. No land value. All claims.
Five 26. Petitioners before this court are 459. So some have not come. And the assessment sheet comprises of how many landowners? 265. This
For different villages, 265 starts from
this is village Nakusora.
yes,
Contains the name of
this is
265.
Mauzam. 265 is in respect of Mauzam village at page 64, Lordship.
Page?
Page 64, name of village Mauzam, number of family affected 265.
Page 64.
Page 64.
Mausam.
And prior to that, another village.
Okay. How many villages?
This is Saisen. 5 villages.
For, I think in the heading of 47 page, draft award, it is written
4 villages.
4 villages.
Comprising
Nakuktora,
of 4 villages. If you add up all the 4 villages, the figure comes to 526.
yes.
Okay. Yes, Mr. Goswami, please continue.
Yes, my lord. Now, my lord, I go to reference case which my learned senior has cited, reference case number 1 of 2017. It is in page 95, my lord. My lord, I read out the para 19 of 104 page.
Yes.
Now, coming to the next question as to whether such a claim can also be maintained in a writ petition, as already discussed above, claim of interest in solitium is a statutory right of the person interested, and non-payment of such interest in solitium would be failure on the part of collector to discharge statutory duties vested on him. If there is such failure on the part of public authority in the discharge of statutory duty, certainly a writ court would be well within its jurisdiction to issue a writ of mandamus to compel the public authority to discharge his statutory duty. The fact that alternative remedy is available under section 13A and 18, reference is still there, my lord, in this, of the LA Act 1894 would not debar the writ court from exercising such jurisdiction in an appropriate case. My lord, in this judgment, what I perceive from it, my lord, this judgment has nowhere stated that writ court can direct payment of solitium and interest on award which is not based on land value. Writ court shall not direct payment of solatium and interest on a defective award wherein land quantity of area of land itself is not mentioned. So I draw a line. My lord, definitely the writ court has the power to give solatium and interest if the authority has not acted upon. Now the question is, in this case, my lord, the award itself does not state the area of land.
Yes.
Award does not say the market value. No breakup is there, my lord, in this award. And how the writ court would allow direct the deputy commissioner or the respondent to pay interest and solatium based on 23 1A and 2 of LA Act when market value itself is not given. My lord, there are many disputed question of fact in this award, and more so, my lord, these are all village council passes, as appears from the plain reading of the award itself. And there is, my lord, agreeableness. Agreeableness would definitely, my lord, if there would have been some representation before the DC and DC would have sit idle and not acted upon that representation, then also writ court would have directed to dispose of the representation. But there is no representation as such in this brief, my lord, wherein petitioner has given a representation to the DC questioning why I am not being given interest and solatium. Now coming to, my lord, what Rupayan Chakma case, that what my learned senior has said, that it was filed without authority, my lord. My lord, if we see this petition also, this petition is also based on authority. Authority letter is at the last, my lord.
Yes, I've seen.
My lord, in that authority letter also, thumb impressions are given, RTI, LTI. It is written RTI, LTI, but who has taken the thumb impression? Whether it is a notarized document, nothing is there. So tomorrow, I don't know, that there might be a dispute as to this authority letter also, because some of the petitioners have come. Others have not come. That is a probability, my lord. My lord, if I go to the other one also, if I go to the reference judgment, that the village council has said that Rupayan Chakma didn't have the authority, then why the petitioners have not immediately withdrawn the reference case? They could have said that we revoke our authority. This was taken on this was a fraud. So we are withdrawing the reference case with a liberty to file next day. My lord, coming to limitation now, my lord. Now coming to, my lord, limitation. there is an order, my lord, 22/5/2020 in this case, my lord. I have a copy, my lord.
It's here. The order sheets are here.
22/5/20.
It was kept
I
open.
have an unsigned, my lord. I don't know whether last line, my lord.
22/5/20.
Yes, my lord. In a yes, my lord. Last line, my lord. Either in this or on the other one. But
Must
heading
be the other one.
uh,
It's not here in this case. Yes.
my lord, last line.
Delay in latches open.
Yes, my lord. So it is kept open. My lord, the Supreme Court has also said that writ can be revoked or writ can be mandamus can be issued, my lord. My lord, there are three judgments. One is of coordinate bench that my lord might not look into, but the other two judgments, my lord. Para 30
Which one?
of CTN Industrial Development Corporation.
This is on delay.
My lord has what?
This is on delay in latches.
Yes, my lord. This is not this how the writ whether writ can be exercised, my lord. This paragraph 30.
Yes.
May I read this, my
Yes.
lord? The court, while exercising its jurisdiction under Article 226, is duty bound to consider whether adjudication of writ petition involves any complex and disputed question of facts. Here it exists, and whether they can be satisfactorily resolved. Number two, my lord, B. The petition reveals all material facts. C. The petitioner has any alternative or effective remedy for the resolution of the dispute that I have already stated that 18 is there, they went there. Person invoking jurisdiction is guilty of unexplained delay and laches. Ex parte barred by any law of limitation. That is 18.2 is there, my lord. Grant of relief is against public policy or barred by any valid law and host of other factors. My lord, I also say that this B, 30B, that it has come to my notice also, the 30B, that the petition reveals all material facts. This has come to my notice also regarding this judgment which has been withdrawn, which states that a detailed order is there, but that detailed order is not appearing, my lord, here. My lord, page 93. Last line, my lord, second paragraph. A detailed order was passed earlier in this regard on 14/2/2017. So that order is missing, my lord. So it doesn't discloses all material facts. My lord, coming to the next judgment. This is a very new judgment, my lord. My lord might have received it. Supreme Court of India. Free bench. Paragraph 15, my lord.
Yes.
It could thus be seen that this court has clearly held that High Court will not ordinarily not entertain a petition under 226 of the Constitution if a effective remedy is available to the aggrieved person. It has held that this rule applies with greater rigor in matters involving recovery of taxes, cess, fees, and other types of public money, and the dues of banks and other financial institutions. The court clearly observed that while dealing with the petitions involving challenge to the action taken for recovery of the public dues, etc., High Court must keep in mind that the legislation enacted by Parliament and state legislature for recovery of such dues are a code unto themselves, inasmuch as they not only contain comprehensive procedure for recovery of dues, but also envisages constitution of quasi-judicial bodies for redressal of the grievance of any aggrieved person. It has been held that though the powers of High Court under Article 226 of the Constitution are of widest amplitude, still the court cannot be oblivious of the rules of self-imposed restraint evolved by this court. The court further held that though the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion, still it is difficult to fathom any reason why the High Court should not entertain a petition filed under Article 226 of the Constitution.
What was entertained in that case?
My lord,
What did the High Court entertain?
which one, my lord?
To come to this paragraph 15 observation. It was a case of surface.
Yes, my lord.
So it says court should not have entertained the writ petition.
Yes, my lord.
Yes.
I never say that, my lord, the WPC doesn't have the power, but here in lot of disputed facts are there, my lord. So, if WPC is entertained, then, my lord, all disputes has to be settled here itself, my lord. And the other judgment of that reference court of district judge,
Yes.
that, my lord, the writ petition shall not be able to quash it as prayed for in the prayers, my lord, of this writ petition.
Sorry? Come to that
My lord,
submission. What did you say?
my lord, I say that writ petition shall not quash that order of that reference. It has to go to LA appeal.
LA appeal is preferred under what provision? Under the LA Act only?
Yes, my lord.
Let us just see.
See, my lord.
Which section 54 of the
Appeal
LA Act?
in proceeding before court.
Subject to the provisions of CPC applicable to appeals from original decrees, notwithstanding anything contrary to the enactment, timing in force, appeal shall lie on proceedings under this act to the High Court from the award, or from any part of the award of the court, and from the decree of the High Court passed on such appeal. An appeal shall lie to the Supreme Court. So this is the provision.
Shall lie to do subject to provision continue.
Is there any other provision apart from 54? It says subject to CPC.
Subject to provisions of the Code of Civil Procedure applicable to appeals from original decrees relating to the country in any enactment for the time being shall only lie in any proceeding under this. To the country in for the time being shall only lie in proceeding under this.
So the rejection of that reference application, can it be construed as an award?
It is, my lord.
Nil award.
It is an original decree, my lord.
It does not necessarily mean that something has to be
It is
awarded.
not- They have
Even if it's not awarded, even if it's dismissed, it'll be bound to be an award. It'll bound to be an award.
just one moment.
Yes. Anything else?
My lord, in the other matter, in the one difference is there, my lord.
What difference?
Close this one. My lord, if my lord comes to approval, page 99.
Yes.
My lord, it is a joint approval with no specification as to what award, what amount has been approved for this particular award. Page 99. My lord has got this.
Yes.
Which refers to the above, I am directed to convey herewith the approval of government of draft award number 3, 4 and 5 of 2007 amounting to 18 plus crores, only being payment of compensation for construction of Bangladesh border fencing with the administrative district of Lungle district. So it is a joint approval of 3, 4 and 5. So what is the figure approved for 3 is not appearing herein. My lord, in this award, if my lord comes to
Yes.
page 59, my lord, or it is a typed copy, or in the other one,
Page?
I'm giving you. Page 59, I'm coming to the typed copy. The other one is not legible in my. Or in page 55 also, my lord would get it. My lord, it stays in B, my lord, if my lord is in page 55,
Yes.
last part, B, compensation payable on the outside fencing line, deemed damage at the village of so and so, so and so, so and so. So this is outside fencing line. It is deemed damage, my lord. It is not for within the fencing line. Generally, payment is made for compensation for inside fencing line or from 0 point.
But the award is paid.
Yes, my lord, but that has been paid. That is also paid, my lord. Nothing is left. My lord, if my lord see in last line, third paragraph, generally for deemed damages, it is stated that this line would corroborate my argument. Separate scheme for rehabilitation and resettlement of the displaced families will be prepared as decided in state level coordination committee meeting held on 12/4/2007 in the conference hall of PIB Aizawl. So that does not come under Indo-Bangladesh border fencing MOU signed between the acquisition agency, in this case EPIL, and MHA, but that has also been paid, my lord. So this award contains deemed damage for outside fencing line. Which is a difference, which the other award does not have in the other 75 of 2019 WPC.
So how much was paid? 966. 34619.
My lord,
How much was paid?
entire amount has been paid as revealed in the paragraph, para 5, para 6.
No, see, the compensation payable on fencing line comes to 5 crores something. Then the deemed damage is under heading B, which comes to 9 crores something. Then ultimately,
Due diligence is probably, I don't know why they have not objected or whatever it is, whatever the reason, but it has been paid. My lord would come to page 49.
no, while we are still at this page 55, 56. What is the calculation otherwise? Isn't it supposed to be added up? 5 crores and 9 crores?
No, Lordship. 5 crores and 4 crores. The
20
total of deemed damages is 42682.
Okay. Deemed damage is 4 crores. I thought deemed damage was 9 crores.
No, my lord, part, but
Okay. So,
and if my lord would see page 49, para 6, coverage. That may I read, my lord?
Yes.
That thereafter the respondent number 4 and 5 had already taken possession of the land belonging to the petitioner for the purpose of construction of border road cum fencing, and compensation as awarded by the petitioner by way of draft award number 3 of 2007 has also been disbursed to the petitioner by the respondents. That everything has been paid in both the cases. As person interested.
no, it is not their case that some portion of the awarded amount has not been disbursed. They also say that everything is disbursed. Only that solicium interest has not been given. That much.
That I have stated why it has not been.
Anything else, Mr. Goswami?
My lord, I have made it complex, my lord.
Okay.
Learned senior has simplified it. I have CGSC might like
Things are simplified for both parties in their own perspective, but it's been made complex to the court now.
yes.
CGC, yes.
My lord, I'm for the respondent number 4. I filed my affidavit on 30/9/2019.
Okay.
We stated, among others, that the present writ petition is not maintainable. Since the earlier to this writ petition, the petitioner had filed LA case number 1 of 2014 before District Court Lunglei. Then the same has been dismissed by the court due to buried by limitation. However, instead of challenging the dismissal order, the present writ petitioner came to the court by way of writ petition instead of filing RFA, my lord. That is one of my main point. Then regarding the earlier case, the petitioner trying to state that was not within their knowledge. That was done by Rupayan Chakma. However, I stated in my affidavit, para 7, if I may read, my lord, the answering respondent stated that earlier to this present petition, the present petitioner had filed LA number 1 of 2014 before Court of District and Session Judge Lunglei District, Lunglei, and the same has been dismissed on the ground of limitation. However, instead of filing the appeal against the said dismissal order dated 18 September 2014, passed by District and Session Judge Aizawl District, Lunglei Judicial District, Lunglei, passed in LA number 1 of 2014, but the petitioner approached this honorable court by way of writ petition, which could not be maintainable as per law, regarding as to whether Sri Rupayan Chakma, without being authorized by the petitioner and without their knowledge, had submitted a reference petition dated 17/7/2014 under Section 18 of Land Acquisition Act 1894, allegedly on behalf of the petitioner and the landowner, in award number 4 of 2007 and award number 5 of 2007, along with awards number 2 2008, award number 3 2008, and award number 1 of 2009, award number 2 of 2009, and award number 3 of 2009, on the basis of the alleged power of attorney executed in favor of the landowner could not be proved by way of evidence only, could be proved by way of evidence only. As such, disputed question of facts has been involved in the instant case, which could be determined before the civil court only. Hence, the present writ petition is liable to be dismissed. That is our point. Then my second point is that we have signed MOU, Memorandum of Understanding, between our agency, that is EPIL, constructing agency on behalf of Union of India. Then we have signed MOU wherein it is supposing there is a liability relating to the present acquisition, my lord. That should be liability and responsibility of the EPIL, that is the constructing agency, based on our MOU. Especially,
Where's the MOU? Have you annexed it? Or
yes, my lord, I annex
Page?
page 8. Started from page 7. MOU, especially MOU.
What is
number,
the date? 14 December 2004.
Yes, my lord. Para 2, 3, and 7 is the relevant portion, my lord.
Paragraph?
2, 3, and 7.
Would you like to read?
My lord,
Would you like to read the paragraph 3, 2, 3, and
yes, my
7?
lord, if I may. Paragraph 2, my lord. The services to be provided by the EPIL shall be as under number 1, carrying out detailed survey of sector of the project allocated to it. Number 2, finalization of alignment in construction with BSF and DM of the area. Number 3, deciding upon the type of fencing required for sector as per the site condition in consultation with the BSF. Number 4, preparation of comprehensive estimate for the work required for sector. Number 5, submission of estimate to MHA. Number 6, getting the works executed as executing agency. Number 7, handling over the complete works to BSF or nominated agency of MHA. Number 8, rectification of defect during defect liability period. That is number 2. Number 3, EPIL shall carry out survey of the sector for the project allocated to it and shall prepare a comprehensive estimate for the project after identifying the type of fencing required as per the site condition and finalized with the BSF. This estimate shall be prepared on the basis of CPWD norms, whatever applicable, and on the basis of market rate analysis where CPWD rate, etc. are not applicable. These estimates should be comprehensive and should be included for but not limited to the followings. Number 1, survey and field investigation. Number 2, jungle clearance and cutting trees. Number 3, fencing as per type required with the access gates. Number 4, retaining wall, art filling, art cutting. Number 5, IBB road as per the type required. Number 6, link road / access road to BOP and from PWD roads. Number 7, pipe culverts. Number 8, patrolling tracks along the fencing. Number 9, cost of land acquisition. Number 10, cost of security cover. Number 11, other enabling works. Then at para 7, EPIL shall be responsible for liaising with the state government / local authorities for acquisition of land and getting forest / environmental clearance for carrying out the fencing and road and related works. EPIL shall also finalize the alignment of the fencing in joint consultation with the BSF and DM of the area where the fencing and the road is proposed. EPIL shall hand over the fencing, IBB road and allied works after their completion to the designated agency nominated by the MHA. EPIL is that one, my lord. They have to submit it after completion to the MHA.
What about the fund? Who will give the finances?
Here, we stated in our affidavit also, the MHA is only the funding.
Funding comes from MHA. Where is that given in this MOU? Not mentioned.
EPIL is only a contractor. MHA.
However, they have to do their work as per MOU, my lord.
No, that's okay. But where is that funding part? It's not given in the MOU.
We stated here in at para 6.
Of the MOU.
No, my lord, at my affidavit.
EPI shall incur expenditure from their deposit for the execution of the work, and EPI shall submit monthly expenditure statement in the so and so. this is not clear. Shall be, what is this? Recouped by the MHA. Sufficient funds are available with EPI at all times for carrying out the work unhindered. There's some lines missing from this paragraph 6 of the MOU.
Paragraph 11, my lord. Stated.
Paragraph 6 of the MOU is not complete. You're talking about paragraph 11 of your affidavit
Yes, my lord.
or the MOU.
In my affidavit, my lord. The statement made in para 17 and 18 of the writ petition are denied. However, the answering respondent stated that the interest in solatium statutorily form a part of a draft award. It is automatic once the market value of land is determined. Interest and solatium thereon have to be granted, and non-payment of such interest and solatium would be a failure on the part of collector to discharge statutory duty vested on him. Therefore, due to the reason of what have been stated in the foregoing paragraph, there is no any responsibility and liability of respondent in the instant writ petition in this regard. It is submitted that Union of India Ministry of Home Affairs respondent number 4 has entered into MOU with the EPILL respondent number 5 in 2004 to undertake the work for fence for certain stretches in the state of Mizoram along Indo-Bangladesh border. That as per the terms of Para 2(3) of the said MOU, Ministry of Union of India Ministry of Home Affairs is responsibility to release the fund to EPIL for construction of road fence, for construction of border fence and road, wherein the responsibility of EPIL is to acquire the land, including payment of the cost of the further construction. That is my submission, my lord, as per my affidavit.
Yes. Anything else?
No, my lord.
And in respect of the other writ petition, also same thing.
Yes, same.
You have filed the same affidavit.
Yes, my lord.
My lord, one line I missed out, my lord.
Yes, what is that?
Regarding, my lord, the case which that Judamoni or that
Yes.
that in that there is a difference. Herein I have, in this case, the respondent has pointed out disputed question of fact, and in the other one, the advocate who has appeared, he has stated there was no disputed question. If it is to be given, it is to be given. As I have seen in the judgment what my learned senior has read out, which went to Supreme Court, and Supreme Court has in one single line, because there was no dispute.
But why this contempt petition is pending?
Contempt, that will come, my lord, that is there, my lord. We reserve this question of my lord now for the time
Because
being.
SLP was filed, that's why.
No, my lord, I have, we in our, I'm appearing for EPL, then I would appear for NPCC. NPCC has already written for funds to MHA. Now MHA is telling that they have filed a review petition, but review number or any stay order number has not been given. by
Review
MHA. Review before the Supreme Court
against the same order.
against the same order.
Review of that order.
That they have stated in their affidavit.
Affidavit of?
Respondent number 1.
No, affidavit filed in which case?
In that contempt.
Okay, you are there in the contempt also?
That I have come later on. I was not there in their main writ petition and all. Because the advocate is not appearing, so I am there in this contempt.
You are there in the contempt?
Yes,
for,
my lord. I
for
would
one of
be
the
there.
contempt.
I would be there, my lord.
Okay. Yes, Mr. Ramzao, anything you want to say?
Yes, Your Lordship, I think I need some clarification. A number of things have been said. Regarding this, the allegation that no representation has been filed by the petitioners before filing the writ petition. It's a fact that we did not file representation, but the the grievance of the petitioners was genuine, and when we came to know that something was done on our behalf, but not with the authority, then we immediately approached the lawyers who would be able to take up the case. And then thereafter, the matter was taken up before the Honorable Court by filing the first round of the writ petition, which was subsequently withdrawn. And because that was filed with some defects, it was withdrawn, and thereafter, Your Lordship, the reference matter was there, and then that was also taken into account at the time of filing the second writ petition.
But can you clarify what was that observation made in that order?
Your Lordship,
A detailed order has been passed on so and
at
so.
this
What-
stage, since we have not enclosed the order, which was said to be the detailed order passed on certain so and so date.
No, if it had been enclosed, I would not have asked you that question. I would
Yes.
have read it myself.
Lordship,
That's why I'm asking you.
if Lordship permits me, I'll try to make it available tomorrow, Lordship. I don't know why this has not been closed, because that could not be the reason for the withdrawal or for permission to file afresh. But it has been highlighted by the Honorable Court. It was supposed to be enclosed, but it has not been enclosed.
Because this is a common order in bunch of cases.
Yes,
That's WPC 146, 148, 149, as well as 150. All of them were closed by this common order.
yes.
So this order could have been passed in any of this writ petition, perhaps.
I'll try to make it available before Honorable Court tomorrow, Your Lordship.
Okay. What is the other clarification you
The
want
other
to
thing
make?
is,
There is no representation, you accept that.
yes, Lordship. And
Then
they,
as soon as you,
they should have filed an appeal that was against the order of the reference court in connection with reference case, LA case number 4 of 2014.
yes,
Lordship, we have not filed any appeal because what was stated there in the order itself was that what we had tried to project in the said case was that we were not authorizing Mr. Rupain Chakma for the purpose of doing all that. But that was not taken into consideration because of the fact that the case of Rupain Chakma was time barred and dismissed on that ground. And
no, if it was time barred for Rupa and Chakma, it was time barred for you also.
that is true if it is a case of Section 18. If Section 18 is to be taken into consideration, it was time barred. Even for the landowners, it was time barred. But the fact remains that since the present claim under, by way of writ petition is for a statutory right, and for that, Lordship, it has been held by this Honorable Court in the Division Bench that even when no reference under Section 18 is filed, and when the awarded amount is accepted, whether the writ will be entertainable or maintainable, that issue was decided by this Honorable Court. And in that, Your Lordship, it all depends on the Honorable Court as to whether, because of delay, the writ petition would be dismissed or rejected on that ground. And since it was the statutory right of the petitioners or the landowners to seek for payment of interest and solatium under the given clauses of the Act, Lordship, we had approached this honorable court on the basis of the judgment rendered by this court in a division bench.
Mr. Ramzawa, this reference was from which writ petition? Do you have the number or do we have the order?
Yes, Lordship, let me see.
It was in which writ petition?
The petitioner, let me just go through this quoted portion under para 5 at page 117 of
No, quoted is there, date is there, order, but in which writ petition? The reference came from which writ petition? Then this writ petition was ultimately disposed of. You had read that somewhere. Mr. Goswami, are you aware?
No, my lord, I was.
Okay, this is the one. W119. Having answered the reference in the above manner, we send down the record of WPC number 119 to the single bench. Please get this record, okay? WPC 119 of 2015.
119 of 2000. Now, which
My lord, in para 21,
Yes, that's what I just read. 21.
last page.
They say that you should have filed an appeal, LA appeal, against that order instead of filing writ petition to quash the order of that district judge. You say that it was not us who came before the district judge, it was one Rupayan Chakma.
yes,
So we did not go to him, go for a appeal. This is for us, on our part, we are claiming this for the first time by way of writ petition,
yes.
not by way of reference, which is permissible.
And in fact, in our present writ petition, we have sought for the quashment of the order or the proceeding of LA.
Why?
LA. Because it was something which
You're
was
putting
done
your
not-
legs in both boats. One boat, boat A, one is in boat B. Instead of sitting in one boat, you're sitting in two boats. We have nothing to do with Rupayan Chakma. We never authorized him. Yet you say that quash that order. Anyway,
that's
My
one
lord,
thing. Lordship, another clarification. The draft award was faulty, according to them, and not in compliance of Section 11 of LA Act. Mainly on the ground that the area of the land and the amount, the market rate of the land which was acquired has not been properly mentioned in the award. Lordship, if I take a lordship to,
so that is the problem which they have pointed out.
Yes.
Area is not there, market value is not there. So even if one wants to give you the solatium interest, how do we calculate? What would be the yardstick?
and here, I'm taking a lordship to the second case, Chitrosen,
Yes, Chitra.
at page 58, assessment of compensation.
Yes.
As provided under Section 5 of Land Acquisition Act 1894, assessment of compensation for damages and deemed damages to be caused to land, building, crops, and properties was made. the land and buildings and one item of crop, that is coconut, usually grown in the kitchen garden by inhabitants of this border area, falling outside the fencing are deemed damages, as the inhabitants will have to be shifted inside the border on completion of commissioning the border fencing. While making assessment, the provision as laid down in the subsection 1 of section 23 of Land Acquisition Act 1894 was taken into consideration. The uniform rates fixed by the Deputy Commissioner and District Collector Lunglei in 1990 and duly approved by the government, right, so and so, was properly examined in the context of prevailing local market rates of land, buildings, crops, properties, and whatever rates found to be obsolete and unworkable are revised and to make it compatible with prevailing rates. Utmost care is taken not to overlook the rights of the affected families and attempts made to recompense mental injury caused to them in making assessment. Ministry of Home Affairs through EPIL constructing Indo-Bangla border road fencing should therefore pay compensation to the inhabitants or claimants who sustain loss of land, building, crops, and properties and earning. The total amount of compensation payable to the claimants as per compensation statement at Annexure 1 is so and so, rupees 9 crores only. Separate scheme for rehabilitation and resettlement for displaced families will be prepared and decided by the state level coordination committee meeting held on so and so in the conference hall. Now, accordingly, the amount was arrived. As can be seen in the assessment of compensation at page 60, pass number amount that is there. And this amount consists of the cost of land, cost of building, cost of the damaged crop, and all those things were all put together. It does not say that the land is of this size and it will have this market rate as per the prevailing value of the land. It does not say that. But whatever may be the value of the land, Lordship, land has been defined in Section 3A of the Act. It provides that the expression land includes benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. Lordship, may I make a reference to
No, this is the
the
judgment. No.
2011 volume 9.
Just find out what is the order disposing of this writ petition.
2011 volume 9, Your Lordship.
What is that?
It is regarding definition of land under the
2011 volume 9 SEC,
SEC
Page?
page 325. The relevant portion is at page 338. Para 30. May I read the Lordship?
Yes.
It is relevant to notice that the definition of land in section 3A of the Act. It provides that the expression land includes benefits to rise out of land and things attached to the earth or permanently fastened to anything attached to the earth. 31. Therefore, when the Act refers to acquisition of land, the reference is not only to land but also to land, building, trees, and anything attached to the earth. So it's a composite assessment. While my learned friend was asking for a single assessment of the market value of the land. But what they have assessed is not only the land, but also all those other things attached to or fastened to the
No,
land.
that's okay. The proposition is okay, but at least you know very well in land acquisition proceedings, normally market value is determined at the rate of so and so per square feet, like that.
That is true. But,
That is not available
What was
here.
not done could not be.
Now we cannot figure out what is this,
Yes,
how they have arrived to this amount, and they're also remaining silent. They don't want to say anything by filing affidavit.
So we cannot say that this is wrong or cannot be accepted. But thing is, Your Lordship, since they have, the district collector had made an assessment, it was approved by the government, and it was also accepted by the respondents number 4 and 5 by making payment of the assessed amount. And at this belated stage, how can they say that this is wrong or defective or what? It is no longer open for them to say that. If they are to say that, they had to file something akin to, or at least in the form of a writ petition challenging the validity of the proceeding. But they had not done that. They had accepted everything and they had made payment of all that was assessed. Now, saying that it is defective, that will not help them. So, on the basis of what has been assessed, Your Lordship, a direction may be made to make assessment of the interest and solatium, which has become much easier. Interest is on the basis of what was assessed, 12%, and 30% solatium. So, Lordship, this could be done, but now they are saying that this is a defective assessment. Anyway, Lordship, I'd like to they have also stated that amount paid to the landowners was more than the approved amount. We have nothing to say. If they want to pay us more, we are happy. But what they have paid with all their heart, happily, and we have received it. Now, when we claim for more, by claiming rights under the statutory provisions of law, they are making all such objections, which may not be entertainable. And a Lordship, as a Lordship had already seen in the assessment, it was clarified that they are pass holders. But what kind of pass? They have stated that the district council, under the District Council House Site Act, there is a provision for issuance of pass, house site pass.
Under section 4?
Under section 3.
3.
1 and 3. And Lordship, allotment of house site under section 3,
House Sites Act.
under House Sites Act of 1953. So it is within the competence of the village council, and this, according to the authority concerned, is as good as LSC, so far as the house site passes are concerned. But they are not in a position to issue passes for agricultural land, shops, or other establishments. So far as house sites are concerned, they are the authority. And these passes were not issued under Section 211 of Land Revenue Act of 1956 or under the Land Revenue Law of 2013. So the right of pass holders under such laws cannot be compared with the right of pass holder under Section 3 of the 1953 Act of the District Council of Mizoram. And the stand that has been adopted by the respondent number 5 is that the judgment does not state that writ court shall pay interest or solicium on defective award. It will not say. The writ court will not say. And the judgment which has been made by the division bench of this honorable court was that once the market value of the land is assessed, and then it is incumbent upon the district authority, that is the district collector, to make assessment of interest and solicium payable under the relevant sections of the Land Acquisition Act of 1894.
See, Mr. Ramzawa, now, assuming that yes, you have a case, solicium has to be calculated and given to you. Now, question is, how do you calculate? Because the market value has not been fixed. The components are not specifically mentioned. It's generally said that this is the amount, this is the pass, give and take. They have given you have taken. Now, if you go to section 23, subsection 2, it says that in addition to so and so, the market value, the court shall, in every case, give this much from the market value, calculated from the market value.
Yes.
So now how does one figure out the calculation?
Your Lordship, to my humble understanding, the amount which has been shown against the name of those writ petitioners is the market value of the
No, you only say that
the
it's
land.
it's a one component.
Yes.
I mean, it's all in one.
land means
Land, definition of land you read out. It says
Yes.
that everything,
yes,
land value, what is there in the land, everything's included.
yes.
So you cannot say that that amount is a market value. How can that be the market value?
And Your Lordship, if that cannot be done,
Market value.
even in the other case, Your Lordship, I'll just point out the instance.
Land includes benefit arising out of land, things attached to the earth, permanently fastened, or anything attached to the earth.
Yes,
So all these things taken together is the amount given to you. So all these things cannot be taken together as a market value.
in connection with the affidavit in opposition filed on behalf of the respondent number 5 in Citrosen and 551 others. Lordship, the judgment of this honorable court in WPC number 157 of 2017 has been enclosed. In fact, it was a Lordship who was presiding over the court.
Where's the judgment? In which case?
The judgment is in connection with the affidavit in opposition in Citrosen 76 of 2019, second case.
Affidavit in opposition.
Yes.
Filed by?
Filed by respondent number 5.
Right.
Which one?
Page?
Page
Which case?
Page 9.
21?
Page 20.
20 onwards.
20 onwards. Citrosen.
Why was this annexed, this judgment?
This has been annexed.
This figure was very small. We didn't contest and we have given that, this amount.
It's not the amount of
But I
whether it's
say
big or
that, my
small.
lord, without any, with modest approach, I say that, my lord, this has been disposed of.
Yes.
by this court only with direction.
So
But
where's the direction? Just
my
show me.
lord, in page
Paragraph?
26,
Paragraph?
paragraph 15.
No.
Let me-
Direction for making the finding out the market value. Where's that?
Yes, my lord has taken the 75 writ petition or
Whichever it may be, the judgment is here before me. Just tell me the paragraph number.
paragraph is, my lord, in
Huh?
15, para 15.
15 after making such assessment, this much?
Yes, my lord. My lord, forward,
No, this does not,
Before
this
that,
does
the
not
Lordship-
answer the query which I'm making.
Yes.
Where is the direction to determine the market value? Paragraph 14, I think. As would have prevailed on 6/11/2006. Respondent number 3 should fix the market value.
Your Lordship, from para 13, in fact.
Read.
However, another question which arises is with regard to determination of the solicium interest, since the respondent number 3, through the draft award number 3 of 2008, admittedly did not determine the market value of the land being acquired. As already noticed, calculation towards the solicium and interest in terms of Section 23 of LA Act would require determination of the market value of the land. Likewise, as held by division bench of this court in reference case number 1 of 2017, the error or mistake committed by the collector would also include non-awarding of solicium and interest and can be rectified within the ambit of Section 13A of Land Acquisition Act. Therefore, having regard to the position in law, it would be necessary for the respondent number 3 to determine the market value of the acquired, of the land acquired belonging to the petitioner through draft award number 3 of 2008 by taking into consideration the date of notification issued under Section 4 of the Land Acquisition Act, that is 6/11/2006. Para 14. The respondent number 3 is therefore directed to fix the market value of the land of the petitioners, as would have been prevalent on 6/11/2006. Determination of the market value, however, cannot be hypothetical or imaginary, but should have a bearing to the assessment sheet of the draft award number 3 of 2018, where the past numbers and amount claimed by the landowners are given. Respondent number 3, after arriving at the appropriate market value of the land, shall compute the solicium and interest as payable to the petitioners under Section 23(1)(a) and Section 23(2) and also Section 34 of LA Act. Such exercise shall be carried out by the respondent number 3 as expeditiously as possible and preferably within a period of 2 months from the date of receipt of the certified copy of this order. After making such assessment, respondent number 3 shall forward the same to the respondents number 4 and 5 and 6 for arrangement and sanction of the fund required. Respondent number 4, 5, and 6 shall, within a period of 2 months from date of receipt of the collector's assessment, get the amount sanctioned and deposited before respondent number 3. Respondent number 3 who shall disburse the amount to the petitioners on proper identification and as per usual formalities.
Okay, see, supposing the market value has been directed to determine, and which can also be done in the instant case.
Yes.
But what about the area of the land?
my lord, the limitation is also there. In this case, it was not there. Those things were not there.
And, Your Lordship, I had made a reply affidavit, in which I have enclosed the steps that have been taken. Similar. In the earlier case, similar ground was taken. And similar direction was also made in, here we have stated in connection with Dujan Kumar case, WPC number 75 of 2019, Your Lordship.
Where is that?
Reply affidavit in respect of the affidavit in opposition filed by the respondent number 5 in the connected writ petition.
Okay, before that, Mr. Ramzawa, before we go over to the next affidavit, now, what was the issue here? Regarding there being no market value
Yes.
is one thing. And apart from that, delay part is not there. Okay, that's another thing. What about the area of the land? Was it vague in this case also?
Uh,
Ms. Malswamy is here, isn't it? You are simply watching the show. We are all trying to figure out what has happened to this award.
Lordship,
My lord,
uh,
at
Prepared
that
by
time
the
it was
collector.
not
may I take Lordship to the award, draft award at page 54 in connection with Citrosen.
Just a minute, Ms. Malswamy, you see, the problem here is that award is being prepared. Nothing is there except for the name of the person, pass number and amount. So, what is the area of the land? What is the market value? Those things are not there. Supposing today court may want to allow the writ petition saying that you calculate the solution. How will you calculate? Because area is not there. Market value is also not determined. So, what kind of award has been prepared? This ought to have been clarified by the collector. This is the problem, you see. You have made things easier for everyone. Yes, Mr. Ramzav, you were
Lordship,
pointing
at
out
page
something
54
of
of Citrosen.
Chitrosen. Yes.
Draft award number 3 of
Of
2007.
your reply affidavit.
No.
Of
It's
the writ
a
petition.
Writ petition. In the draft award at para 3,
Para
page
3.
54. Just below location of land and nature of passes. There is
Where is
area
the
of land.
compensation statement?
Area of land.
Where is the compensation
My
statement?
lord, at page 60.
Page,
So where is the area?
No, not nowhere mentioned, my lord.
areas of land assessed are as given in the compensation statements.
This is of the year 2007. Supposing we want to see the statement today and call for the records, will it be available? It will be 2007. How many years back? 17 years back. They may or they may not have also, we don't know. Mr. Ramzawa, you wanted to refer to paragraph number 3. Area is as per the statement. Statement does not say anything. It just says name, father's name, village, pass number, amount, signature. So we have to go one step ahead from the other judgment. Not only you determine the market value, you also go and measure the land now.
Yes. May not be measurable now.
If the record is available to ascertain the area of land acquired, then it will be easier for the Honorable Court. If if direction is made for production of the record so far as area is concerned. Otherwise, we'll have to go back to the land and take measurement. In the meantime, they had already accepted all that was said, and it's only for the purpose of assessment of interest and solatium. Otherwise, if proceeding is drawn afresh under the 2013 Act, it will be much easier. Otherwise, Your Lordship, the petitioners are put to undue suffering.
That cannot happen, my lord, under this new act, 2013 Act, because of section 24(2), 24(1)(b).
Which says,
My lord, if
if it's not complete,
this is complete, if award is pronounced,
If the beneficiaries are not given the awarded amount, then it can be taken over to the new act.
there are-
Otherwise, my lord, the whole thing has not been paid, so there is no impossibility. No, that is not a prayer. If there is lapses on the part of the authorities concerned, why should the petitioners, the landowners who are ignorant of the law and the procedures, why should they be made to suffer? That is another aspect of the matter, Your Lordship.
so we'll do one thing. We'll call for the records. Hearing is complete, otherwise, this will remain as a part heard.
All right. And subject to the availability of the record, whether Lordship will allow us to address the Honorable Court.
No, what else do you want to address?
my lord may call for records and keep it as CAV. If the records are available, then my lord, this would be based on records only. We do not have anything to say, my lord.
No, we'll not CAV at the moment. We'll just say, call the records. And perhaps on the date when the records arrive, we'll make it CAV.
Because other issues also to be determined regarding limitations and all, my lord.
No, those things you have already addressed. That will be taken care of
Yes, my lord.
at the appropriate time. The only thing is that since the collector has not filed the affidavit, might as well ask for the records. And we'll see. Please write. The parties have been heard at length. Stop. However, before taking a final decision, in the matter, court would like to peruse the original records pertaining to award number 3 of 2007 and award number 3 of 2009. Prepared by the District Collector cum Deputy Commissioner Lungle in respect of Indo-Bangla Border Road cum fencing. which were pronounced on, what is the date of the pronouncement of the award? On 12/10/2007 and one 6/2010 respectively.
2010.
Ms. H. Lalmal Swami, learned government advocate, shall produce the relevant records by the next court date. List the matter again. When? 3 weeks.
My lord, I would prefer 25th, but my lord, bench should has to be available because it's a part heard matter. As per roster.
We'll make it 3 weeks. List the matter, 1, 2, 3. Again, after 3 weeks, along with the relevant records. No. Again, after 3 weeks, the matter shall remain as part heard.
Yes, sir.
So depending on that, the registry will accordingly post it. Let this remain in the file. It's okay, open.
This is Judamani, no? Judamani.
Item number 6.
Lordship, this contempt petition,
Why is it listed today?
Lordship, affidavits have been exchanged. And I have
Yes.
received a letter.
My lord, I have filed an affidavit today, but that has become defective because I have omitted, it is my mistake. I have omitted one paragraph wherein I have didn't give the mobile number and all for as per that new direction.
Okay, mobile number is not given.
Yes,
So it
otherwise-
could not be filed.
Yes, affidavit I have filed, copy I have.
You are supposed to give your mobile number.
Yes, my lord, that was a recent direction that I can be contacted on so and so mobile number. That paragraph I omitted. That is my mistake, my lord.
Could it not be handwritten?
My lord, it is notarized in Delhi.
Okay, notarized in Delhi. Anyway, what have you stated in the affidavit?
My lord, I have written 5 letters to MHA for payment. My lord, that letters already has been in, if my lord go to last order,
Yes, 13/1, 15/2, 2/3, 8/6, 15/7
yes.
of this year.
Yes, my lord, that is already in part of record. Those only I wanted to give.
So what is the point? See, you have already mentioned about the letters. You
Yes,
wanted
my
to incorporate that in your affidavit, that's all.
That is my lord. That is what I wanted to incorporate.
No. So what difference does it make?
That it doesn't make any difference.
You have already informed the court that you have written so
that
many
I have
letters.
informed the court, my lord.
Now, who is responsible for making the fund available?
My lord, if that whatever the record is there, if that record is taken out, my lord,
Which record?
that marked out last time the letters I have given. That is marked as X or something.
Oh, these are the letters.
Yes. My lord can apprise the situation now, my lord.
What? How much is the amount?
My lord, on 13/1 I have written before that the case has been decided and before contempt proceedings comes, please take up. And last letter, my lord,
You are for which respondent?
I am for 3.
Respondent number 3.
R.K. Agarwal. That I am being implemented later on. My predecessor was there as respondent number 2. I joined later on, my lord. The last page, my lord, of that R.K. Agarwal.
Name is not here.
Which one, my lord?
Okay, number 3.
Number 3, my lord.
Chairman, Managing Director, NPC.
NPCC.
So the fund will come from the
MHA.
MHA.
Yes, my lord. Now, I have written, my lord, in my last letter. My lord would see the last page.
Last letter is dated.
Last letter is dated 15/7/2024.
Yes. What have you written?
My lord, para 5 onwards. That in the contempt proceeding being contempt case number 2 of 2020, the petitioner has also filed a petition along with fresh assessment dated 18/3/2024, wherein the assessed amount is rupees 8,58,11,747. The said assessed amount has increased to 8,58,11,747 from 6,16,45,077, which was the assessed amount as on 15/7/2019. There has been substantial increase in the amount payable with time and no result from litigations, and hence NPCC has categorically decided that no further futile litigation to be brought in and waste time and bring burden to state exchequer. Under the aforesaid circumstances, approval is sought for payment of interest, solatium and other statutory liabilities amounting to rupees 8,58,11,747 till 18/3/2024, and to further approve for payments if in case further demand is made by landowners for payment of interest, solatium and other statutory liability till the date of payments. The aforesaid amount to be released by MHA to NPCC for payment at the earliest.
Is addressed to whom?
This letter is given to MHA, Director BM3. It is Border Management 3, Ministry of Home Affairs, Government of India.
Who is implemented? Is a party here?
Secretary. MHA.
Secretary is implemented.
Yes, my lord. We have earlier written to Under Secretary to the Government of India also, my lord.
Copy is given to Secretary
Yes, my lord.
also. Is there a separate secretary for border management?
I have no idea, my lord. There are
But this
many-
is your letter.
Yes, I have.
So
yes,
just have a
it-
look at the end
Yes,
of
it
the,
is copy to Border Management. It has to be there.
and the secretary rate here in this present contempt petition is just secretary to the government of India,
Yes.
Ministry
MHA.
of Home Affairs.
And I don't know whether he is there or not also on date.
Yes, Ms.
Mr.
Sankvi, what do you say?
My lord, I filed my affidavit on behalf of Ajay Kumar Bala, respondent number 1. Now he is released from his service, my lord. Now we
He's-
have a new secretary. We filed.
Before his release, what did he do? Apart from taking time,
to did the new one, my lord. However, as on date, I'm not.
no, please answer my question. When the contempt petition was filed, he was very much in office. Isn't it? Otherwise, why would they implead somebody who was already retired? He was in office at the time. So what was his reply to this contempt notice? Did he file any affidavit?
Yes. You have filed affidavit. no?
Yes, I filed
What does he say?
22/8/2024.
What does he
They
say?
stated that the Union of India has decided to file a review petition. However, they didn't state it about whether they file it or not, or whether it has registered it or not. That is why I have supposed to inquire the matter, my lord. If I may permit this some more time to inquire the matter. In the meantime, we have a new secretary now.
My lord, I'm intervening, my lord, with apology. My lord would come to page 8 of their affidavit. Third paragraph.
Their affidavit means the affidavit
Filed by Ajay Bhalla, petitioner number 1. Respondent number 1, my lord.
page.
8th. Third paragraph. No, I am taking the role of petitioner's counsel, but anyhow, my lord. Third paragraph. On the decision of SLP, the Union of India has decided to file review petition before the Honorable Supreme Court, and the review petition is being filed before Honorable Apex Court for review of the order dated 4/1/2024. They have said that they have filed it. Now, if they have not filed it, it is perjury.
Review petition is being filed. So
Against the order which is quoted just above, that small order, which was order passed by the apex court. We are not inclined to interfere with the impugned judgment and order passed.
So
by
what is the update on this review petition?
My lord, I already sent letter regarding this, but I'm still awaiting reply.
How will you get a reply? By writing or how?
Yes, my lord, by
How?
writing. Because since I didn't have the personal contact number of Ajay Kumar Bala,
Do you have his address?
address to the secretary. my lord.
You get the address? If he's retired, get his private address also. We'll take it up again.
My lord, in para 20, it is given the number.
That is the office
Where?
number.
Para 20 of the same affidavit at page 9.
That is not my, the personal number of the Ajay Kumar Bala.
The mobile number in which I can be contacted is 9 so. So this is his phone number.
The office number, my lord.
So you find out from the office his number, get in touch and get the updates about the review petition.
Yes, my lord.
We'll take it up again. When can you get it?
After 2 weeks.
Not 2 weeks. You'll make a phone call. Doesn't take 2 weeks to make a phone call.
My lord, give as well, if there is possible, there is no inconvenience, then I also may be given some time, because I would correct the affidavit and file the.
No,
file
that's
it.
up to you. If you want to file again, file it.
within this week, Your Lordship.
Please write down the respondent number 1 in his affidavit filed on 22/8/2024 at paragraph 16 has stated that the Union of India has decided to file review petition before the Supreme Court to review the order dated 4/1/2024 passed by the said court in SLPC diary number 43460/2019. And the same is being filed. Stop as such till disposal of the disposal of all legal remedy available comma, it may not be construed as contempt of the court. Next para, Ms. Zarem Sangpui, learned CGC, shall obtain up-to-date instructions by the next court date. Stop, the same is required despite the fact that she has submitted that the respondent number 1 has in the meantime retired from service. Stop, the contact number of the respondent number 1 is available in the affidavit, and the learned counsel for respondent number 1 shall make an endeavor to get necessary information by the next date. Next para, Mr. P. Goswami, learned counsel for respondent number 3, submits that there was some error in the affidavit that was prepared to be filed for respondent number 3, and therefore he prays that he may be given some time to make the rectification and file the same.
Lordship, may I also make a prayer for submission of the name of the new incumbent for the purpose of impleatment.
Before that, in the top, that Ms. Zarem Sangpui's submission, one more line, you had one more line. Ms. Zarem Sangpui, learned CGC, shall also inform the court about the name and details of the new incumbent occupying the post of Secretary to the Government of India. What is this? Ministry of
Ministry of Home.
Ministry of Home Affairs.
Border management, that within bracket it is BM is, I have given my lord later. I have given later Secretary BM.
Different secretary. Board of management may have a different secretary, my lord. Which secretary is for whole secretary for Ministry of Home?
That's what I had asked the councils. What is there any, are there more than one secretaries in this? You find out and inform the court. List the matter again. When? Today is 22nd.
By Friday, Lordship.
Friday, very difficult. We'll have it next Tuesday. On Tuesday. This is the matter again on 29/10/2024.
Item number 7.
My lord, in this matter, even though I was given liberty to file my rejoinder affidavit to the counter affidavit filed by the private respondents, I will not be filing any rejoinder affidavit. So the matter can be taken up for admission hearing.
Okay. Mr. Uh,
Sheetlan Thiang Lim.
Seetlan Thiang Lim, learned counsel for the petitioner submits that after going through the affidavit of opposition, the petitioner has decided not to file the rejoinder affidavit after all. Full stop. He therefore summons that the matter can be taken up for admission hearing. Full stop. In view of above, when? List the matter for admission after 2 weeks.
After 2 weeks, my lord. In the meantime, my lord, if the interim may continue.
Interim order is there.
Yes, my lord.
Interim order passed earlier shall continue till the next date of listing.
Deeply obliged.
For hearing, item number 11.
Well, the matter, if Lordship allows us to get it adjourned.
We can continue
Next
if you
week.
want.
Both are already, my lord.
Don't look at the watch. We can continue.
We are not in the mood anymore. We're exhausted, my lord, before we begin. If possible, next Monday, my lord. Tuesday, they are going to have their matter again. So,
After hearing Mr. Ramzawa's short submission,
my lord,
you've become exhausted.
yes, my lord, that is the main reason why we're here.
When should we have it?
Monday, if possible, Lordship.
Monday, if possible, my lord.
Monday is slightly difficult because I think second half I might have a meeting. So it will
right,
not be possible.
Tuesday. Sympathy. I wonder if the earlier Puramzawa and his party are going to take up their matter on Tuesday, my lord. So
Which
if that
case?
is-
Which case?
that one, the earlier one. Just
No, no.
before us, my lord.
That's only for instructions only.
Okay, all right. That is the case, then we can take up on Tuesday then.
Please write, due to paucity of time, the matter could not be taken up today. As agreed to by the parties, let's list this matter again on
29.
9th
My lord.
October 2024 for hearing.
My lord. Oblige.
Item 12 has been mentioned already.